Memo, sir. Fresh matter.
Fresh matter.
Give memo, sir. Give fresh memos. Please just bear with them. They will adjust. All fresh memos. Kindly give all fresh memos.
My lord, I pray one thing, my lord.
Just kindly, madam. Just be patient with your colleagues. Allow them to just complete. They will look at it.
Transfer person, the case is posted for 15 January night in the family court wardrobe.
Fresh matter, madam, you have to give memos. Tomorrow, no prioritization. They will adjust the matters, no prioritization, because it is a transfer matter and listed tomorrow. That is not a criteria for picking up matters.
Family court wardrobe, 15 January, the case is posted.
15th, family court cannot dictate the roster of a high court and listing. That you must also understand. There is no such provision in high court rule. Whenever a matter is listed in family court, high court has to take it up. All matters are urgent. So, but out of turn, it's a question of you are requesting it for out of turn. So, all memos you list it. All will be listed. Madam, ko dekhiye jete jaldi hi pariyo. But please don't expect that out of turn. Madam's matter will be, your matter will be preferred and her matter will go down the list that way not. Yes, madam, please. After notice matter.
No, my lord. Fresh matter, my lord. In this case, the wife of the present prisoner.
Kindly don't argue on merits.
My lord.
You have heard already. So, a lauded trial court taking up a matter, you try your best to get adjournment and all that. Like you are mentioning, convince that court to give you some time. And there is no such order which can be passed by the trial court which cannot be overturned or when status quo ante cannot be restored. There is no such matter also. No order can be done.
Okay.
Yes. Unless the matter is finally disposed of.
Oh, bless it.
Yes. Page wise jantu?
Page 4.
Page 1 aram kari. First dinner just allow them some time. Please, one humble request that please don't take adjournments. Let us try to touch and finish matters. But for at least for these এটা সেটি কারণ তো ক্যালেন্ডার সেটিং নেই কাজ যায় দ্যাট ফেব্রুয়ারি হাত তো পটনায় ক্যালেন্ডার নেই কাজ চারিদিকে চারটা ক্যালেন্ডার মানে জানিও না নাকি ল্যাক অফ কমন সেন্স ଫେବ୍ରୁଆରୀ ସେଟା ଗୋଟେ ଜାଗାରେ ଗୋଟେ ହାତ ପାଇବନି ଆପଣଙ୍କର ଯାହା ଉଚ୍ଚତା ଏପଟେ ଆସନ୍ତୁ बहुत ऊंचाई for this week. Please be don't adjourn matters. That's a request. Anyway, page 1.
1 to 8.
I don't know, see, my lord, may be permitted to.
Kindly file memo. If memo nahi, tale paper diyo.
Yes, sir.
Rita withdraw. What's your name, sir?
Suryakant Deep.
3 days Suryakant. Deal, okay. Yes, deal.
Thank you.
Yes, sir.
Page 2. Item 9 to 15.
My pardon, that item 9, my lord.
What do you want, sir?
But due to shifting of my chamber, I could not.
Adjournment.
Due to my shifting my chamber.
Time, sir. How much?
No, my lord. Because I want to take a copy of the brief that the pen drive been able to copy and permit me to file requisition by
So
tomorrow.
I have to pass a order.
No,
So please wait. Yes, next. 10 to 15.
10 to 15.
16, 17.
That's button.
Sorry, sir.
Item number 616.
16, sir. Yes.
They have not supplied me the copy of the objections. Since
You are there for?
I'm for.
So it has to reach, sir. You have to look at it. You are not yourself sure. So let us reach it. You can see the paperless brief there. Whom you are appearing, what is your submission? Yes, next.
Page 4. Item 18 to 24. Page 5. 25 to 33.
That's item 30 permit to process.
30 withdraw.
Yes.
File memo, sir.
Yes.
What's your name, sir?
Sheikh Mehrullah, sir.
Okay. But the order will be passed when the matter reaches. Please appreciate. Yes.
So mutual divorce age.
Whatever, sir. I have to look at the brief, then pass orders. Don't worry. It will be taken care of. It's a Memo, you just mention the name, the serial number, so that they don't misplace it. Serial number টা পকেইଛନ୍ତି তো? বলুন। এটা কি সব বন্ধ করে দিস?
basic
Save it তৎকাল।
34 to 40.
Item 36 mile, I am
Yes.
for the opposite party.
Yeah,
I pray for 2 weeks time to file count.
sir, where is the author? So Mr. Yes, Mr.
Mr. Mahathi is there.
36 simply adjourn कर दियंतु।
Interim to continue.
Is it for the interim order to continue?
Manage.
You are seeking Mr. Rai 2 weeks time.
2 weeks mile. I am Tripathi.
2 weeks. Date गोटे ହେଇପାରିବ? ଦେଇପାରିବେ ଏବେ? Looks ପରେ। ନା ଆପଣ କେମିତି ଲିଷ୍ଟ କରିବେ? Week commencing କରିବେ ନା ଡେଟ୍ କରିବେ ନା? Week commencing କରିବେ। ଆଡଜଷ୍ଟ କରିବା ସୁବିଧା ହବ। କରନ୍ତୁ।
Full commencing 27.
Week commencing 27
एक 2024.
27 କହୁଛନ୍ତି। Days?
Wait.
Yes.
Item 1.
One, yes, state, so we will pass over. Can you accommodate? Do you have time?
State is not a party.
Not a party. Okay. So pass over, sir.
Item 2.
Pass over, sir.
My lord, in item 2, my lord, I am in VC, my lord.
Yes.
My lord. My lord, the petitioner is the husband of opposite wife.
Sir, can you bring, sir, you have to show your face and photograph, sir. You can't be dark and blackness. How we will proceed, sir, without you appearing?
My lord,
VC, but you should appear in VC.
my lord, my lord.
ଆପଣଙ୍କ ଯଦି କଣ କ୍ୟାମେରା କାମ କରୁନି ଯଦି ତାର ଆଉ ଥରେ ଜଏନ୍ କରନ୍ତୁ ଦେଖନ୍ତୁ।
My lord. My lord, good.
ଆପଣ ଯେମିତି ମତେ ଦେଖୁଛନ୍ତି କୋର୍ଟ ଦେଖୁଛନ୍ତି ସେମିତି ଆପଣ ଦିଶୁନାହାନ୍ତି ମିଷ୍ଟର ସିଂ।
Madam, I am. ମୁଁ ଦେଖିପାରୁଛି ଆପଣଙ୍କୁ।
ହଁ ମୁଁ ଆପଣଙ୍କୁ ଦେଖିପାରୁନି ଆପଣଙ୍କ ଫଟୋଟା ଦେଖିବେ ଭିସିରେ ଆସୁନି।
My lord. My lord, 1 minute permit, I will join in the phone. My lord, 1 minute. 1 minute.
ପାସ୍ ଓଭର ଠିକ ଅଛି ଆପଣ ଚେଷ୍ଟା କରନ୍ତୁ ଆସିବା ପାଇଁ।
My lord, 1 minute.
Yes, Mr. Ponda, item 1.
Prayer for return of dowry article has been rejected.
RP farm na nahi,
No, read petition.
writ petition is maintainable.
Yes, ma'am.
By which court, sir? Prayer for dowry article?
Family court.
The
Family court,
judgment?
Noyagarh. Annexer 4, page 48, mine.
Any proceeding pending?
Now no proceeding is pending since the wife is dead in the meantime.
Huh?
And the parents of the wife claims return of dowry article. This is the issue.
Can you look at the judgment which you are challenging? Which one you are challenging, sir?
Annexer 4, mine.
The 27 Hindu Marriage Act.
Page 45, my lord.
48 you have to read to understand the provision.
Mine.
How a writ is maintainable against 27? Can you don't look at
Yes,
me, look at
yes.
your brief, page 48. And
I may pray
for the
first,
request, please get the books, read the
Annexer-
brief and read the statute. That becomes
Let
easier
it come
for.
tomorrow, I will.
No, can you? Tomorrow will not help you, sir. Just look at it. Tomorrow, sir, definitely I am liberal
Yes.
in granting adjournment. Look at page 48.
Well, first kindly see
You will
Annexer
not
3,
see
mine.
2048, then have to record it. After repeated request, the learned counsel doesn't want to open the brief,
Sorry, mine.
and according to the matter cannot be taken up.
A petition under section 27 of Hindu.
Look at the top. CP number
CP.
230, it says CP under 27,
Yes.
Hindu Marriage Act. How a writ will lie against it?
The matter.
You have to educate me that 226 is the right. I'll be happy to exercise writ jurisdiction. But does the court have jurisdiction to maintain a writ petition against section 27 petition in Hindu Marriage Act? And it's a CP also. Then kindly read further under 15(1)(c), 16 Hindu Succession Act, 7(c) Family Court Act.
My lord.
There is no concept of writ petition against these provisions. Please
It's
examine
for
this.
some time.
Mr. Gyanananda Panda, he writes JNYA. Mr. Gyanananda Panda for the petitioner. The writ petition has been filed challenging the order dated 27/1/2025, passed by the Learned Judge, Family Court, Noyagarh, in CP number 230 of 2024, filed by the petitioners in the CP, who are appellant before this court. Stuff. By the said petition, the petitioners, who are the parents of deceased Srimati Sadhana Manjari Dalai, had filed petition under section 27 of the Hindu Marriage Act, read with other provisions of Hindu Succession Act, with section 7(c) of Family Court Act, the said CP was stop कर लिखिए. The said CP has been dismissed by the Learned Judge, Family Court, not being maintainable amongst other grounds. Stop. Para. The Learned Council has adjournment to examine and address whether writ petition would be maintainable against the order of Judge, Family Court in a proceeding under section 27 of the Hindu Marriage Act 1955. How much time, Mr. Panda? When do you
1
want?
week after.
Accordingly, the matter is adjourned to be listed on about a week commencing to be listed in the week commencing
16.
16 ହେଇପାରିବ ନା further ଚାହୁଁଛନ୍ତି?
ଆଉ ଗୋଟେ
ସେପଟଟା
27.
27/1/2024.
ହଁ 27.
Simply ଆଉ ଗୋଟେ ଫାଇଲ କରିକି ଏଟା withdraw କରିଦେବେ.
ନାଇଁ.
Because conversion in an appeal will be difficult because
Right.
grounds and other things have to. Yes. Yes, Mr. Singh, are you back? Yes, Mr. Singh. Item 2.
Item
Now you are visible.
My lord, sorry, my lord.
Why sorry, Mr. Singh?
I am
Yes, Mr.
my lord. My lord, in this case, the petitioner is the husband and the opposite party is the wife, my lord. The petitioner filed application, entry application number 27 for 24 of the Hindu Marriage Act for interim entrance and pendence of the litigation expenditure, my lord. In this case, the wife has filed a petition for
Parental Act Maintenance 24 মানে RPFM বোধে
না সেটা ফাইনাল ডিসপোজ হয়েছে এটা আইটা ফাইনাল ডিসপোজ ফায়ার ডিসপোজ রিট হবে যেটা আরপিএফএম হবে না আরপিএফএম টা হবে যদি ক্রিমিনাল আসবে
আপিলটা কাହା against ରେ হବ
মাইলর
MATA কাହା against ରେ হବ
মানে যে ফাইনাল ডিসপোজ ହେଇଯିବ ଯଦି ସିପିଟା ଫାଇନାଲ ଡିସପୋଜ ହେଇଯିବ ତାହେଲେ ହବ ବଟ୍ ଏଇଟା ଆଇଏଟା ହଉଛି ଇଣ୍ଟ୍ରିମେଣ୍ଟାସ ଆଇଏଟା ଫାଇଲ ହେଇଛି ମିସ୍ କେସଟା
3298
ଡିସପୋଜ ହେଇଛି
ଦେବା ଜଜମେଣ୍ଟ ହେଇଛି
ହଁ ମିସ୍ କେସ ରେ ଜଜମେଣ୍ଟଟା ହେଇଛି 24 ରେ ସେଇଟା ହବ ରିଟ୍ ହବ
କେମିତି ଏମିତି ଆପଣ ବ୍ରିଫ ଦେଖୁଛନ୍ତି ନା ନାଇଁ ଆପଣ କ୍ୟାମେରା ବ୍ରିଫ ଦେଖୁନାହାନ୍ତି
ବ୍ରିଫ ଧରିଛି ମ୍ୟାଡାମ
ହଁ ଦେଖୁନାହାନ୍ତି ମୁଁ କଣ ଅଲଗା ବ୍ରିଫ ଧରିଛି ନା କଣ ମେ ବି ଆଇ ମେ ବି ରଙ୍ଗ ଅଲସୋ ଆପଣଙ୍କର ଇଣ୍ଟରନାଲ ପେଜ ରନିଂ ପେଜ 19
ଆଜ୍ଞା
ପଢନ୍ତୁ ଏଇଟା ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି
ନାଇଁ ଆଜ୍ଞା ତା ପରଟା ଆଇଏ 13 ବା ଆନେକ୍ସରେ 2 ଟା କରିଛି ଆଜ୍ଞା ଆନେକ୍ସ 2 ଟା ଅଛି ଆଜ୍ଞା
ଆଇଏ
ଆଇଏ 13 ବା 2024 ଆଉ ଗୋଟେ ଆଇଏ 16 ବା 2024 ଟା ଏଇ ଦିଟା ଆଇଏଟା ଡିସ୍ପୋଜ ହେଇଛି ସେଇଥିରେ ଏଣ୍ଟ୍ରି ମେଣ୍ଟେନାନ୍ସ ଆଲାଉ ହେଇଛି
ମାନେ ଆପଣ ବୁଝିପାରୁନାହାନ୍ତି ତାହେଲେ ଆପଣ କୋଉ ସିପି ରେ ଆଇଏ ଫାଇଲ କଲେ ଟ୍ରାଏଲ କୋର୍ଟ ରେ ଆଇଏ ତ ଖାଲି ଫାଇଲ କରିନାହାନ୍ତି ଗୋଟେ ସିପି ଥିଲା କୋଉ ସିପି ସେଟା
ସିପି 48 ସାର୍
ସିପି
ସିପି 48 ସାର୍
ସେଥିରେ କଣ ସେ ସିପି ର ପ୍ରେୟାର କଣ
ସେ ସିପିର ପ୍ରେୟାର ହଉଛି ଡିଭୋର୍ସ ପାଇଁ ହେଇଥିଲା
ହଁ ସେଟା କଣ ହେଲା
ସେଇଟା ଏଇ ଆଇଏଟା ଡିସ୍ପୋଜ ହେଲା ପରେ ସେଇଟା ଡିସ୍ପୋଜ ହେଇଯାଇଛି
କାଇଁ ସେଟା ସେ ଯୋଉ ସିପିଟା କଣ ପେଣ୍ଡିଂ ଅଛି କଣ ଅଛି କୋଉଠି
ନା
ଲେଖିଛନ୍ତି
ସେଇଟା ଡିସ୍ପୋଜ ହେଇଛି ସେଥିରେ ଡିସ୍ପୋଜ ହେଲା ପରେ ଆମେ ଆଉ ଗୋଟେ ମାଟା ଫାଇଲ କରୁଛୁ ସେ ମାଟାର ନମ୍ବରଟା ହଉଛି 362/2025
ସେ ମାଟା ଅଲଗା ଏଟା କେମିତି ଅଲଗା ହବ ଆଜ୍ଞା
ଆଗେ ଡିସ୍ପୋଜ
ସେକ୍ସନ 24 ମାଟା
ଡିସ୍ପୋଜ
ଅଲଗା
ହେଲା
ହବ ଆଜ୍ଞା
ଆଗେ ଆଇଏଟା ଡିସ୍ପୋଜ ହେଲା ଆଗେ ଆଇଏଟା ଡିସ୍ପୋଜ ହେଲା ପରେ ମୁଁ ସେ ଆଇଏଟାକୁ ଚ୍ୟାଲେଞ୍ଜ
ମାନେ
କଲି
ଆଗେ ଯୋଉଟା ହେଇଛି ବର୍ତ୍ତମାନ ପଛରେ ତ ଫେରେ ମାଟାଟା ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଗଲା ନା
ହଁ ଆଜ୍ଞା ପଛରେ ପୁଣି
ସିପିଟା
ମାଟା
ଡିସ୍ପୋଜ କଲା ଆପଣ ମାଟା ଚ୍ୟାଲେଞ୍ଜ କଲେ
ମାଟାରେ ପଛରେ ଚ୍ୟାଲେଞ୍ଜ ହେଇଛି
ଦୁଇଟା ପାରାଲାଲ ପ୍ରୋସିଡିଂ କେମିତି ହବ
ମାନେ ସାର୍ ସେଇ ଯୋଉଟା ସିପି ପ୍ରୋସିଡିଂ ଥିଲା ଡିଭୋର୍ସ ଥିଲା ସେଇ ସିପି ପ୍ରୋସିଡିଂ ରେ
ମିଷ୍ଟର ସିଂ ଗୋଟେ କଥା 10 ଥର କହିଲେ ହବ ମୁଁ ବି 10 ଥର କହିବି ସେଥିରେ କଣ ହାଉ ଡଜ ଇଟ୍ ମେକ୍ ଏ ଡିଫରେନ୍ସ ସାର୍ କ୍ୱେଶ୍ଚନ ଇଜ ଭେରି ସ୍ପେସିଫିକ ଆପଣ ଗୋଟେ ସିପି ଫାଇଲ କଲେ ସେକ୍ସନ 9 ନା 13 କଣ ଫାଇଲ କରିଛନ୍ତି
13 ରେ
13 କଣ ହେଲା
13 ଟା ପରେ ଡିସ୍ପୋଜ ହେଲା ଆଜ୍ଞା
ପରେ ହେଲା କି ଆଗ ହେଲା କଣ ହେଇଛି ସାର୍ ସିପି ରେ 13 ରେ
ସିପି ରେ ଡିସମିସ ହେଲା ଆଜ୍ଞା
ଡିସମିସ ହେଲା ତାକୁ ଚ୍ୟାଲେଞ୍ଜ କଲେ ନା ରହିଲା ସେରିୟରେ
ଚ୍ୟାଲେଞ୍ଜ ହେଇଛି ଏଠି ଆଜ୍ଞା
ତାହେଲେ ଚ୍ୟାଲେଞ୍ଜ ହେଲେ ଏଇଟା କେମିତି ଅଲଗା ହବ
ତା ପୂର୍ବରୁ ସେଇଟା ଆଇଏଟା ହେଇଛି
ତାହେଲେ ସେଇଟା ଏଇଟାକୁ ଆଉ ଥରେ ସେଥିରେ ଫାଇଲ କରିବେ ଏଇଟା ୱିଡ୍ର କରିବେ
ସାର୍ ମୋର କହିବାର ଜିନିଷ ମୋର କହିବାର ଜିନିଷ
ସାର୍ ମୁଁ
ହେଲା
କେମିତି ଟେକଅପ୍ କରିବି ଗୋଟେ ଗୋଟେ ଆପିଲ ପେଣ୍ଡିଂ ଅଛି ମୁଁ 24 ମୁଁ ଟେକଅପ୍ କରିବି ସେ ଯୋଉ ଡିଭିଜନ ବେଞ୍ଚ ସିଏ କଣ କରିବେ
ସାର୍
24 25 ଆପଣଙ୍କ 24 ରିଜେକ୍ଟ ହେଇଛି ତ
24 ଟା ପାର୍ଟଲି ଆଲାଉ ପାର୍ଟଲି ରିଜେକ୍ଟ
ସେଟା ଯଦି ଆପଣ ତାହେଲେ ମୁଁ ଅଲଗା କେମିତି ହବ ସେଟା ଆପଣଙ୍କର ଆପିଲ ରୁ
ସାର୍ ଆପିଲ ଟା
ଆପଣଙ୍କର ଆଇଏ ଯଦି ଗୋଟେ ସେପାରେଟ ସିପି ହେଇଥାନ୍ତା ହଁ ଗୋଟେ ଦ୍ୟାଟ ଇଜ ଲାଇକ ମିଷ୍ଟର ଜ୍ଞାନାନନ୍ଦ ପଣ୍ଡା ୱାଜ ଆର୍ଗୁଇଂ ଇଭେନ ଦେନ୍ ଅଲସୋ ଦେयर ଇଜ नो ପ୍ରୋଭିଜନ
ସାର୍ ସେଇ ଯୋଉଟା ପ୍ରଥମ ସିପି ଥିଲା 48 ଥିଲା ସେ ପ୍ରଥମ ସିପି 48 ରେ ଦୁଇଟା ଆଇଏ ଫାଇଲ ହେଲା
ଆପଣ ସେକ୍ସନ 24 ରେ ରିଟ୍ ମେଣ୍ଟେନେबल ଯୋଉଟା କୋଉଠି ଅଛି 24 ଚ୍ୟାଲେଞ୍ଜ କଲେ ଆଫ୍ଟର ଡିସ୍ପୋଜାଲ ଅଫ ଦ
ସିପି ଆଫ୍ଟର ଡିସ୍ପୋଜାଲ ସାର୍ ନୁହେଁ ସାର୍ ସିପି ଟା ଡିସ୍ପୋଜାଲ ପରେ ହେଇଛି ପ୍ରଥମେ ସାର୍ 24 ଟା ଆগে ଡିସ୍ପୋଜ ହେଇଛି ପେଣ୍ଡିଂସ ଅଫ ଦି ସିପି
ଆପଣ ଯାହା କହୁଛନ୍ତି ଫେରେ ଭୁଲି ଯାଉଛନ୍ତି ସିପି
ନାଇଁ ସାର୍
ଡିସ୍ପୋଜାଲ ଫାଇଲ କରିଛନ୍ତି ଆପଣ ଆଗ ପଛ ଖାଲି କହୁଛନ୍ତି ଆଗରେ ହେଉ କି ପଛରେ ହେଉ ଆଇଏଟା ଆରେଞ୍ଜ କଲା ସିପି ରୁ
ଆଜ୍ଞା
ସିପି ଡିସମିସ ହେଲା
ନାଇଁ
ସିପି
ସିପି
ଚ୍ୟାଲେଞ୍ଜ
ଡିସମିସ
କଲେ
ହେଇନି ଆଜ୍ଞା
ଏମଏଟିଏ
ସିପି
ଆଉ
ଡିସମିସ
ଆଉ
ହେଇନି
ଗୋଟେ ରିଟ୍ କେମିତି ଫାଇଲ ହବ
ସାର୍ ସିପି ଡିସମିସ ହେଇନି
ତାହେଲେ କାହିଁ ଏମଏଟିଏ ଫାଇଲ କରିଛନ୍ତି ସାର୍
ସାର୍ ସାର୍ ମୋର ଟିକେ କହିବାର ଅଛି ଟିକେ
ମାନେ ଆପଣଙ୍କ ଯୋଉଟା କହିବାକୁ ଅଛି ଆପଣ ଶୁଣନ୍ତୁ ସାର୍
ସେକ୍ସନ 13 ରେ ଡିଭୋର୍ସ ଫାଇଲ କଲି ସିପି ଟା ସେ ସିପି ରେ ମୁଁ ଗୋଟେ ଫାଇଲ କରି ପରେ ମୋର ମେଣ୍ଟାନ୍ସ ପାଇଁ ସେକ୍ସନ 24
ପାଞ୍ଚ
ଫାଇଲ
ଥର
କଲା
କୁହନ୍ତୁ
ହଜବେଣ୍ଡ
ମିଷ୍ଟର ସିଂ
ୱାଇଫ ଫାଇଲ କଲା
ମିଷ୍ଟର ସିଂ ମିଷ୍ଟର ସିଂ କାଇଣ୍ଡଲି ଲିସନ ଆପଣ ଭିସିରେ ବିନା କାରଣରେ ଭିସିରେ ବି ସମୟ ନଷ୍ଟ କରୁଛନ୍ତି ଆପଣ ସିପି ଫାଇଲ କଲେ ସିପି ଟା ଡିସମିସ ହେଲା ପରେ ଡିସମିସ ହେଲା କହୁଛନ୍ତି ଆପଣଙ୍କର ଆଗ 24 ଡିସମିସ ହେଇଛି ପାର୍ଟଲି ଆଲାଉ ହେଇଛି ବା ପାର୍ଟଲି ହେଇଛି ତାକୁ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ରିଟ୍ ରେ
ଆଜ୍ଞା
ହାଉ କ୍ୟାନ୍ ଇଟ୍ ବି
ସାର୍ ସିପି ଟା ପେଣ୍ଡିଂ ଥିଲା
ବର୍ତ୍ତମାନ ସପୋଜ ଆଇ ରିମାଇଣ୍ଡ ଦ ସେକ୍ସନ 24 ଫର ରିକନସିଡରେସନ where it will be reconsidered I will direct the division bench
नो ସାର୍
then ଟିକେ ଭାବନ୍ତୁ ଆପଣ କଣ କହୁଛନ୍ତି
ସାର୍
ଆପଣଙ୍କର 125 ସିଆରପିସି ର ଜୁରିସଡିକ୍ସନ ଆଉ ପ୍ରୋଭିଜନ ଅଲଗା ସେକ୍ସନ 24 25 27 ତାର ପ୍ରୋଭିଜନ ଆଉ ଜୁରିସଡିକ୍ସନ ଅଲଗା
ସିପି ଆଜ୍ଞା
ଆପଣଙ୍କର had learned counsel for that item too had learned counsel for the appellant petitioner at length the petitioner has filed writ petition challenging the order passed by the learned judge family court Hon'Ble dated 2/8/2025 in IA number 13 of 2014. IA number 13 of 2024
and 16 number 2024.
at 16 of 2024. The said IA does not refer to the CP that was filed seeking a divorce under section 13 of the Hindu Marriage Act by the divorce किए फाइल करते मिस्टर सिंह
Petitioner my lord, husband my lord.
by the petitioner husband. It is submitted that the CP number kuantu CP number kuantu
My lord, 1 minute.
CP number
My lord, 1 minute.
19 of 2023
No my lord, 48 by 24 my lord.
48 of 2024 was filed by
Husband.
the petitioner husband seeking
Divorce 13.
seeking a grant of divorce. Seeking divorce or invoking provisions of section 13 of the Hindu Marriage Act was dismissed. The cause title of the IA shows that the IA arises out of CP case number 48 of 2024. The CP judgment date कौन थी 48 रा
14/8/2025.
The judgment, it is stated by the Lord Counsel for the petitioner that the CP was dismissed by judgment dated 14/8/2025, which is under challenge in MATA filed by the petitioner. That is MATA number
Matter 362 of 2025.
362 of 2024.
25 my lord.
2025. 362 of 2025. The Lord Counsel for the petitioner has adjournment to address on the issue whether during pendency of a matter challenging the judgment passed in CP before the division bench, another writ petition can be proceeded with challenging order rejecting IA, disposing IA filed under section 24/25 of the Hindu Marriage Act arising out of the same CP, which is subject matter of adjudication before the division bench. Another aspect, Mr. Singh, 25 is alimony, permanent alimony, which cannot be adjudicated by a single bench. It has to go to the division bench along with the matter. You cannot make a separate challenge to 25 also. That is another problem. And 24 after disposal of CP, what 24 I will remand, suppose reconsideration. After disposal of the CP, how 24 is maintainable?
My lord,
It cannot be.
my lord.
It can be a 24 before the division bench, not before the trial court. How much time, Mr. Kebe kohibe?
2 ସପ୍ତାହରେ ଥାଉ 2 ସପ୍ତାହରେ any date will.
Accordingly, the matter shall be listed after 2 weeks. as paid for in the week commencing
36.
27/1/2025.
My lord, it is humbly submitted. Earlier, I had filed the matter, but office pointed at that matter.
Earlier, after, together, these things have relevance when the matter is pending.
My lord.
So earlier, after, together cannot, endow me with read jurisdiction to deal with appeals.
Office pointed at office. I have filed a matter, but office pointed at it as not a matter. It is it. Then thereafter, the conversion file. After
Again, Mr. Singh, you have mixed up. Matta challenging section 24 or 25 separately is different, and Matta challenging the final order in 13 is different.
Humbly obliged, my lord. I had filed
You
earlier
have
my
not
matter.
challenged, so you should have realized that. After you have filed section challenge, after you have challenged the section 13 judgment and decree, there you should have filed whatever challenges you can make.
My lord.
125 CRPC, earlier 125 and DV Act are different.
My lord.
Hindu Marriage Act, Family Courts Act are different.
My lord.
And in the Odisha High Court, Hindu Marriage Act, Family Courts Act is a division bench subject and appeal have to be filed.
My lord.
In that pending matter, you have to file IA, whatever if you want.
My lord.
In fact, you need not make a separate challenge in writ petition or IA. The reason being you have challenged the entire judgment. That merges, interim order merges with the final judgment. Yes, next.
Item 3.
Mr. S. Dheer, learned counsel. Mr. S. Dheer for the petitioner. Memo of date is filed by the learned counsel, Mr. S. Dheer, for the petitioner seeking to withdraw the writ petition. The writ application was filed with the following prayer. Prayer ta quote kar de. In view of the memo filed on behalf of the petitioner, the writ petition is disposed of. ऊपर जो लिख लेनी कि memo of date is filed, इतने लिखते हुए is taken on record. The copy of this order shall be forwarded by the registry to the learned judge, Family Court, Bhubaneswar, to be tagged to the file of CP number 45 of 2020. Yes, please, next.
Item 4.
Mr. Saubhagya Kumar Samal for the petitioner. Mr. Yes, Mr. Samal.
My lord, petitioner before your lordship is the husband, and he has filed a CP before the London Judge Family Court under section 13(1) for divorce.
Yes.
And his limited prayer before your lordship for a direction to the London Judge Family Court for early disposal.
So where you have stated that that's the only CP pending. I am unable to dispose of the MATA CP. So how I will direct a court? If this is the only CP pending before that court, I can direct. Somebody approaching High Court for discriminating other litigants, how an order can be passed?
This is the only CP. Only.
You swear it on affidavit, I'll obtain instruction.
Yes, Lord.
Only CP before that Family Court Ganjam?
My lord.
No. You are wrongly instructed. Look at the number.
No,
CP number 296. How it can be the only CP?
No. No other litigation.
No, that I am not asking. I am asking about the court.
My lord.
You have to swear on affidavit that this,
No.
This is the only matter pending before the court for consideration.
Sorry.
How I will pass a order that his matter or Mr. Agarwal's matter, Indian matters, which is pending, your matter to be taken up early. It is misconceived. And there are judgments which directly says that these orders are not to be passed by superior courts. And it's a 2023 matter.
Because the opposite party number 1 wife is not cooperating. That is.
Non-cooperation of a party, the court's hands are not tied. That also you must appreciate. It is neither tag nor the law is blind to that. You will file a petition for dismissal or whatever or allowing. That petition will be treated on merit.
Right.
That can be challenged. But this petition, I
That
cannot
observation, your lordship,
so what observation I will make?
the petitioner,
Shall I move the court? I don't know. Appropriate steps you have to take.
madam,
Writ petition has been filed seeking a direction for early disposal of the CP number 296 of 2023, pending before the learned judge, Family Court, Ganjam. This court is of the considered view that simply somebody approaching the court for prioritizing his case at the cost of other litigants cannot be allowed. At this stage, the learned counsel for the petitioner seeks to withdraw the application, files memo of date, which is taken on record. The writ petition is disposed of. Yes.
problems.
Item 5,
On behalf of Mrs. Jenny, kindly pass it.
Pass over. Call करो.
6,
I request for a short pass over.
Pass over.
7,
May I please?
Yes.
Lordship, kindly have a glance, order dated 25/1/2024. I think,
Viscusit file ହେଇଗଲା? File ହେଇଛି ନା ହେଇନି ଜଣା ପଡୁନି.
my lord, I am
So in that scenario, it's better if you file press requisites.
your lordship may direct.
Actually, if you are unable to,
Yes,
so
because last noting the earlier counsel was engaged as stated that he has already filed requisites.
I am
He is appearing, my lord.
for all.
OP4,
Samantray.
OP3, my lord. OP3, my lord.
State in
OP3.
So J. Samantray, your name is there.
Yes.
Yes, he is appearing, my lord.
Already.
So why
That the delay is there.
16 days delay is there.
court fee you have paid?
Yes, man. Nothing is not there for court.
I have to check the order. Okay, just look at the paperless, look
Right.
at the office notes. Notices were issued by order retreat. Number 5.
No notice has been issued.
नहीं ये
There is no notice has been issued.
नहीं
Which notice issue?
notice issue is yes,
One and two admit.
ସେ ପୁରା 24 25 ଏକରେ ଅଛି ଏଇଟା
9/3/19 ରେ ଆପଣଙ୍କର ଯାଇଛି ଲୋକ ଅଦାଲତ ତାପରେ 13/7 ରେ ରିମାଣ୍ଡ ହେଇଛି ଫେରେ ଡାଇରେକ୍ଟେड ଟୁ ବି ଲିଷ୍ଟେଡ ଫର ରେଗୁଲାର ବେଞ୍ଚ order number 5 court fee accepted and notice order number 6 notice is issued 21/12/23
21 बार.
pursuant to the notices issued by the ordinate bench by order dated 21/12/23 Mr. J. Samantray submits that he has entered appearance.
Notice on question of limitation was issued.
ଯାହା ବି ହଉ ସେଇଟା ତ ଆଉ ସେପାରେଟ ଏବେ କରିହବନି once he has appeared how can we separate that he has only appeared for limitation and not for the appeal କଣ ଲେଖ has entered appearance on behalf of Niranjan Paikre,
Yes, OP3.
P3. Mr. Dayanand Leka, Lord Counsel, Lord Additional Government Advocate, appears on behalf of the OP number 1 and 2.
Yes, my lord.
Respondent হবে বুঝলি মানে opposite party respondent, appellant petitioner. This order is in delay. You want to file objection or will condone the delay?
16 days.
The Lord Counsel, Mr. Samantare, taking a fair stand, submits that in view of the delay in filing the appeal being minimal, that is 16 days, the matter can be considered on merits after condonation of delay. So, condonation of delay would not add any further merit to the case of the appellants. Stop. The Lord AGA also submits, the Lord AGA also submits that the delay can be condoned and the matter can be considered on merits. The foreign condonation of delay present. Accordingly, the delay of 16 days in filing the appeal is condoned. The IA is favored and disposed of.
Miscase number 36.
36 रे कौन ପାଇଁ କରିଛନ୍ତି
37/16.
Limitation.
36 सीट है
No, 37/16.
this case 37/2016 ଟା ଅଛି limit 37/2000
ଅଲଗା ଲେଖା ହେଇଛି ଆମର
release condoned and ହେଲା
37 ଟା ଅଲଗା
এটা ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କଲେ ଆମାଉଣ୍ଟ ଟା ଡିପୋଜିଟ୍ କଲେ ସେଠି କରିବେ ନା ବିଲକୁଲ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି नो ଲାୟବିଲିଟି ଟୁ ପେ କମ୍ପେନସେସନ
ସେଟା ହଉଛି ଏନହାନ୍ସମେଣ୍ଟ ଟାକୁ ଆମେ ଇଏ କରୁଛୁ ଚ୍ୟାଲେଞ୍ଜ କରୁଛୁ
जो अमाउंट टा आपनको डिपॉजिट करिया कथा ना करिया कथा नो दैट्स अ क्वेश्चन टू यू
माय लॉर्ड
यू एग्जामिन दैट
माय लॉर्ड
ओके रीट अपील लिखंतु हार्ड लॉर्ड काउंसिल लॉर्ड तो करुणाकर नायक सीनियर पैनल काउंसिल फॉर द अपीलेंट लिस्ट इन द वीक कमेंसिंग केबे आसले हबो
एनी डेट यू लॉर्ड
you suggested date so that it can be listed with 2 weeks 1 week
yes one week
Mr. Samantare.
Yes, madam, 1 week.
And you address whether the amount has to be deposited or not regarding that. What is the law on that? Provision and law.
Yes.
You likely had on it the petitioner appellant, the appellant railways and Union of India challenged the order under section 18 of the Land Acquisition Act 1894 dated 39/2015 passed in LA miscase number 9 of 2010 by the learned senior civil judge Noyagad in LA miscase number 09 of 2010 directing enhancement of land acquisition compensation to the respondent number 3 pursuant to the notification number 52059 देखी लिखिए पेज 8 रे अछि dated 8/11/2006 तापरे हार्ड लर्नेड काउंसिल फॉर द appellant senior panel counsel appellant list in the week commencing केबे कले 27/1 list for admission कर दियंतु
specific date
there is some he is trying to adjust it gradually he will do it the week commencing 27/1 कोन अगर स्पेसिफिक डेट ले असुविधा हो से वीक रे आसी जीवो yes
इसे डेरी करियो
yes next कोन कहले
my lord the name of the earlier council may be deleted
the कितना नंबर आइटम
7
a name of Mr. Abhijit Pal and Mr. Kartik Chandra Jaina learned counsel who are appearing earlier for the appellant shall be deleted from the cause list as well as case brief as learned counsel for the appellant. The name of Mr. Karunakara Naik, London Senior Panel Counsel, is already reflected. Upon reflect H.
Obliged.
Yes.
item A,
Pass over.
9,
Item 9. May I pray that?
Yes, please. ଆପଣ କହୁଥିଲେ ଏଟା adjust
ଆଜ୍ଞା।
କରିବେ ବୋଲି
ନାଇଁ sir.
copy.
I am permitted
The
to
Lord
take copy
counsel
of
for
the.
the
I am permitted to take copy of the B by that pen drive method. Thereafter,
so SK Joshi for the
by tomorrow I'll file.
the matter has been listed with office note that requisites for issuance of notice to OP number 3 by registered post oblique speed post with heading not received. Para. It is submitted by the Lord Counsel for the petitioner that due to shifting of his office, he has misplaced the case brief. So, he seeks for need to obtain copy of the soft copy of the writ petition from the registry. Prayer is allowed. The registry shall permit the Lord Counsel for the petitioner to obtain soft copy of the writ petition as well as annexes as per the extant rules. Then further if the requisites have not yet been filed for issuance of notice to OP number 3, the same shall be filed for issuance of notice by speed post with registration with proof of delivery within how much time, sir?
3 days time.
Within 7 working days. If not filed,
Yes. Much obliged.
Upon filing of the requisites, the registry shall proceed to issue of notice, fixing returnable date.
Much obliged.
The matter shall be listed after SR, service return. Liberty to mention. Mr. Dayanidhi Lenka for the. Mr. Lenka, you are there for
Yes.
all.
No, OP number 1, 2, and 3. For OP number 4, notice is necessary.
3. Sure. 1 and 2.
Yes, 1 and
1 and 2. So Dayanidhi Lenka for the 1. Yes. Setira receive करिकी सेटा को उसे फाइल लगेबे. Mr. Samal Dele. Yes.
Item 10, my lord.
Item 10.
Yes, my lord.
Yes, please.
My lord, in this matter, the appellant is challenging the maintenance order passed by the learned family judge Jagat Singhpur. My lord, there is
which provision, sir?
under 125, which has been filed, maintenance, my lord.
Have you deposited any amount?
My lord, there was already a CMP pending before this honorable court where the appellant has challenged, but that has been suppressed.
I could not get you, sir. I could not get you.
My lord, in CP.
No, sir. Kindly. Since I have not been able to follow you,
Yes,
so please listen to my query and then kindly answer. Don't expect that the judge will not ask you anything to understand the proposition. You have filed a RPFM challenging the order passed by the learned trial court in 125 CRPC petition or the domestic violence?
125 CR.
125 CR. Where is the order?
So, Annexure 1, my lord. Order.
It is ex parte?
Yes, your lordship. It's an ex parte order. There is delay in filing this present RPFM.
How do you say ex parte order? Why you have said ex parte?
My lord, in page number 34. Page number
the order starts at page 11. Have you examined pages 11 to 34 where it has been stated that you have been set ex parte?
My lord, there is no exact date mentioned on which date I have been set.
That is the difficulty, sir. If you don't look at the brief, look at page 12, order dated 5/8 to 2021. Page 12, paragraph subpara 3. Kindly read it aloud for us, for me.
Peruse the case record. The original CRP filed in this CRP, the opposite party husband appeared and filed his show cause. It is submitted that petitioner is set petitioner side in this interim maintenance petition that the petitioner number 1 is the legal married wife and petitioner number two is minor daughter of the opposite party. It is further submitted that due to various physical and mental torture imparted by the opposite party on petitioner, intervention of Tirtol police was sought for in.
Just read the paragraph before.
It is
So now you have understood
Yes, sir.
that he has appeared and filed.
I-
You are saying it is ex parte.
I-
Be careful when submitting as far as basic facts are concerned.
I apologize.
No, why should you? Then I will not discuss. Why should you apologize? Sir, you are a lawyer. You should not, sir. These are the courtroom deliberation, nothing personal. Then kindly read the paragraph above.
Heard from the side of the petitioner as the counsel of opposite party refused to receive the copy of interim maintenance petition and did not file any objection to the above petition, so the matter is heard from the side of the petitioner only.
So how can the appellate court take up this matter? I'll do the same mistake. If you say the Lord trial court proceeded on erroneous thing, but the fact what you are saying is not recorded, so you have to bring this to the notice of the Lord trial court. This attitude of not applying maintenance orders is prevalent. But attitude is fine, but this is not the legal way to do it. In a case where you have appeared, a IA is filed, the Lord Council refuses to accept. The court is not helpless and hapless, will wait. Now it has come to your notice, it is an order of 2021.
My lord, I may some place before your lordship annexed.
No. Before placing anything, since you are so apologetic, kindly answer this 5/8/2021 order. That's a court order or not?
Yes, your lordship.
In your petition or not?
Yes, your lordship.
So you have to answer that.
My lord, actually.
Otherwise, I have to be apologetic in passing a wrong order. Is it not? And court should not be apologetic. Court has to do justice, go by law. You have to make a best effort to present the case. And this is not the way you do not have the impression, correct impression have not been given to you. Maybe, I don't know.
Hello, this is
How you are going contrary to the record. How the appellate court will proceed contrary to the record. Then kindly look at case 13, last paragraph. The same, what you are holding now. You are holding 12, you don't have to turn much pages. The next page.
Yes.
Look at the subpara. On going through.
On going through the SOCOS filed by the opposite party, it is found that the opposite party has not disputed his marriage with petitioner number one. He further admitted that the petitioner number one is their minor.
Two, not one.
Petitioner number two in their
is not him, is their minor daughter.
Is their minor daughter. He also submitted that now both.
So what is the otherwise also on merit? There is no case. You do not have any case. What is the ingredient of 125 CRPC then? Since now repealed, the same provision is there. Which court will not allow 125 CRPC after on the record because it is a pending proceeding? She is your wife and say the child is your daughter.
My lord, already CP was pending, that has been suppressed. It was the order has been passed.
You are not getting, sir. So your answer in this CRPC proceeding will say that I am already paying 5,000, 10,000, 20,000. So the prayer in the 125 CRPC may be considered in that context. The court will be happy to pass that order since he is already paying, but you do not appear. You refuse to accept copy.
Lord, I am not aware of.
So don't take these chances with the court. The attitude of non-paying and taking chance with the court. This is absolutely no merit and it should be dismissed with a heavy cost.
My lord,
This suppression of CP, it is your duty to bring to the notice of the court. If I record, then I have to explain that your conduct. The CP you are paying, you are saying?
Yes, sir.
Why you have not stated before the court? What prevented you? It's a pending case. When do you want?
My lord,
or today I will dismiss it.
My lord, there is a limitation petition.
Whatever, sir, limitation or other. I will not condone now because I have considered on merits. Both limitation and merits I have considered. In merits, you have no case.
My lord, I pray after 2 weeks.
Your name, sir?
Sanat Sushohan Panda.
Mr. Sanath Sushobhan Panda for the petitioner. The petition has been filed with the following prayer. If you are saying, Mr. Panda, I am recording it and it is found untrue, then there will be further problem. How much you are paying in say that CP?
Malab 2,000 rupees per month.
Since when and up to what? You file a memo.
Already it is on record. Some of the payment receipt as there on record on Annex 3.
Sir, this is not a SOP, sir. Where it is in the record in the lower court records order, what you are just now read, which you are challenging, where the court has delved into that, because the court says you refuse to accept copy and the court proceeded.
My lord, this is the payment which I am doing right now is pursuant to CMP number 1.
How many times, sir, then you have to apologize? You are not following even. You are saying when the court proceeded with this petition filed by the wife, it did not consider the order passed in the other CP. You are using the word suppressed. Now the question is where you have brought this to the notice of the court to consider. There you are struggling. You have to find me for that. Maybe that I have not read it correctly. You have filed it, a petition or your objection to that. But Sapara first order, Sapara says that you refused. कौन लिख ले? Challenging so and so, ना? The order dated 6/11/2019, not 6/11, 5/8/2021 in CRP number 79 of 2019 discloses the following. Page 12 रे अच्छी 12 para 1 para से सब marking नहीं. Page 12 para 1 sub para 2 sub para 3 up to लिखिए page 12 पे जति अच्छी sub para 3 up to other of the petitioner number 1 passed away, say per example. Then cross gap subpara on going through the SOCOS filed by the opposite party, page 13 up to 48 dot up to of petitioner number 1 since 20.3.2012 সেটা লিখিবে. It is submitted by the learned counsel for the petitioner that the petitioner is paying rupees 2,000 as maintenance to his wife and minor daughter pursuant to the order passed in order dated kete?
Order dated 6/5 of 2022.
6/5/2022. Order dated 6/5/2022. Then you are absolutely wrong, mister. This maintenance 5,000 is 21. Then how it will be? How you are saying that it is suppressed? Na buji parunanti.
But I pray for an adjournment, my lord.
Order dated 6/5/2022 passed in CP number. Kete CP number kontu?
CP number 68 of 2000.
No adverse order is passed today. Only facts are recorded. So why you are don't panic. 68 of
2014.
2014. Though it is contended that the learned trial court has not, learned just family court Jaipur has not considered, but apparently the order directing payment of maintenance at rupees 2,000 per month is subsequent to the order dated 5/8/2021 passed by the learned judge in CRP number 79 of 2019. The petition has been filed after a delay of
189 days.
189 days. At this stage, learned counsel for the petitioner seeks and has adjournment. Accordingly, the matter shall be listed in the week commencing केते समय चाहुचंती
2 weeks.
2 weeks पर दियो
27
the week commencing 27/1/2026 पासवर्ड डाकी दियो
पासवर आइटम 5
next
पासवर आइटम 6
6
Well, there are two writ applications
yes please
against two independent orders, but both the orders actually divulge pinpoint one particular issue regarding the study of the child, whether she will be studying in kids or in DM school Puri. The matrimonial issue actually, no divorce proceeding, nothing has been filed. Both are living separately, but independently they are residing. Husband resides at Puri actually. So they have got a house at Bhubaneswar. The girl's house is at Bhubaneswar. She actually was working in Bangalore, where both husband and wife and the child was residing there. Your Lordship knows in technical, technicians, right, electronic subject and all that, they send a deputation to foreign countries. So she was deputed to go to Canada. So she went to Canada, she got the passport of the child also, and both of them went to Canada, stayed there. After some time, she also returned back. Then the husband said the schooling should be there in India, and therefore they decided to have it with the father. The child resided for some time. The wife again went back because that's a 10-year basis services. When the mother came back and said that now the passport has to be renewed because I want to take back the child for her studies there also.
in Canada,
That was refused. The husband didn't give consent. Therefore, an application was filed for getting the passport done in the absence of husband's consent also. So that was also pending or has been refused. That is pending. That is pending before the High Court Parade. Now actually, the child has been admitted in kids.
international school,
Right.
International Bhubaneswar,
Bhubaneswar.
by the wife, by the mother. rather.
By the wife. But the transfer certificate is registered by DM School Puri, and they say will not grant the transfer certificate. So therefore,
Ground, sir?
ground that husband is saying that no, don't allow the transfer certificate. Husband is staying at Puri.
Here, Mr. Mishra, you have to find out this. I mean, much less the court. Actually, the child's future is involved. At least some truth should be there in the fighting between the husband
Child
and wife.
interest is paramount.
She is in which class?
6th class.
Fifth is a minor child, and she will be confused where to study and.
No, actually, we want to give the child a better education.
So I'm issuing notice. Let them appear.
The only thing is, if you also look at the order, the child is now in kids. So child has been admitted in kids. She is prosecuting her study in kids.
No, without they appearing, even that becomes difficult.
No, I don't want your worship should kind of look at the order. If your worship looks at the order, operative portion, then your worship will satisfy why I am anxious actually. Page 67, my lord.
Yes.
It says, as such, prisoner 1 is directed to facilitate prisoner 2 to continue his studies in DAV Public School, Puri. In case the prisoner or any of the member of her family restrains the prisoner from continuing education in DAV Public School, Puri, the respondent is at liberty to bring in the fact notice and knowledge of the local police. In that event, the local police shall take suitable and appropriate steps to enable the order of this court to take motion, both the prisoner disposed of. So he is prosecuting in kids.
Mr. Kindly look at page 66.
Yes.
The subpara.
63, my lord.
66. Internal page 3.
I'm sorry. Yes.
the court, it reads the petitioner number 1 categorically submitted.
Yes.
Kindly place that.
That on 8/12/2025 and the objection date is 16/12/25 that prisoner number 2 is studying his case in the school. However, the fair fact needs for adjudication. I don't know what adjudication is required. It's also difficult to accept submission that he is studying in another school without taking transfer. So that's the reason an application is filed. They should send the transfer certificate. He is studying because if you also kind see, we requested the principal to give us a. Kindly say the principal has given on my request that so the evidence that he is prosecuting the kids. Girl says, no, lady. Sure. So it is a fact that the boy is prosecuting in kids. And it may be viable, but not possible to get a certificate of completion of education.
Take notice by speed post.
Yes, I'll take notice, but this order should not be given if
yes, regarding police and all that, that maybe the court went in a haste.
Yes.
It appears because
I don't know. This is a matter. There is no dispute. Both are husband and wife. And wife has got a right also. The child is a
they
minor.
require counseling. Because they are before the court. Family says Bhubaneswar, the son, the minor is also a petitioner.
Yes. Minor is represented through
the mother.
Mother.
So mother wants where the child should read. Mother wants what police or kid.
Kids. Husband's job does business, job in Bhubaneswar. But he wants the boy should study at DAV school Puri. Just ego, nothing else.
And the boy is also in Bhubaneswar?
Yes, boy is in Bhubaneswar. He is in
maybe the court, I don't know whether the court was confused or what.
I don't know why such an order has been passed. Police will intervene and take the child to Puri.
Mr. ST, Ms. Senior Advocate, along with Mr. R.K. Agarwal. Mr. R.K. Agarwal for the petitioner. Here again, the child is also the petitioner. The mother, the petitioner number 1 is the mother, and the petitioner number 2 is the minor son. Her minor son.
Her minor son.
Her minor son born from the wedlock with the OP number 2. Okay. And this GUAP separately, should it not be taken up together with the GUAP? GUAP is pending.
Yes.
Passport renewal.
Passport renewal is also pending.
GUAP, this matter is not connected.
Yes. That is related to renewal of passport, which is actually
renewal of passport.
The minor.
Out of no. Out what amount I can upon भर्ती कर देने. फिर sorry भर्ती कर देने था. With OP2. The mother and child are before this court challenging the order. The mother and the child represented through her are before this court challenging the order 64.
2/1/2026.
Order dated 2/1/2026 passed by the learned judge family court. Bhubaneswar in CP number 666 of 2025. It is submitted by the learned senior advocate that from the cause title of the CP as well as the writ petition, CP 666 of 2025 before the learned judge family court as well as the writ petition, it is apparent that the mother and child now stay at Mahavir Nagar, Samantrapur, Bhubaneswar, and the opposite party has also given his address. So the respondent opposite party has his address at Bhubaneswar. at
Plot
Ashok
30.
Nagar, Bapuji Nagar,
Plot
Bhubaneswar.
38 Bapuji Nagar.
Bapuji Nagar, Bhubaneswar. It is submitted that the child is admitted to KIT International School at Bhubaneswar. Staying at Bhubaneswar now. Due to the matrimony between the petitioner and the petitioner number 1 and the OP has run into rough feathers. There is apparent dissension between the couple that has impacted the studies of the child. The child now is studying in class 5. The certificate issued by the principal, KIT International School, copy of the certificate, 7/1/2026 is produced before this court and taken on record. The petitioner number 1 in particular is agreed by the operative portion of the order 2/1/2026. Which reads as follows. On Likhibe, which is available at para marking to nahi, which is available at internal page 4 of the order. As such, the petition number 1 is directed to facilitate petition number 2 to Neki, page 67 Raj, internal page 4, up to filing of written statement. As an interim measure, it is directed the said order, the said portion of the order shall not be given effect to. It's further clarified that this order is passed looking at the welfare of the child, as the child should not be the subject matter of the litigation, creating difficulty for his studies. The learned Judge Family Court is also requested to take up the matter on the next date, that is 3/2/2026. And consider the aspect of study of the child at Bhubaneswar without prejudice to the rights and contentions of the parties in the CP as well as in the writ petition. So it is after 3/2 it should be listed.
Yes.
Till then, let it be there be.
You know, sir, that operative portion is as such. It starts from
as such.
As such. As such.
As such.
Sir.
Yes. As such should proper lecture up to this.
Both the writs are same order. If one looks at
second matter is
second say husband file a petition that has been allowed. So directed DAV school, Puri.
Just 1 second. Page?
Sir, at page 34. It is operative portion, therefore
in such circumstances,
right.
Second page, therefore in such circumstances. But Mr. Mishra, one thing, if he's continuing already at
DAV school
Puri for the half of the education here,
right?
Because whether he took admission recently or not, that is not very clear from the order.
So they have
not considered.
They have accepted. He's accepted that he has not completed 6th class, will admit in 5th class, but they have both a boarding as well as residence students. So there is a better future for the child, in fact.
In fact,
Education is better, future is
in
better.
some cases, the High Court has also directed for a KIT international.
Right, right. Because the
Say,
wife
operative portion da paile. Second writ application hochi 764 of
pays
2026.
34 and therefore
Page 34, it starts, reads, therefore in such circumstances, up to for filing of written statement. Now the child's custody is with
mother with
the upuru jota likhe, which is submitted by senior advocate, that the child's custody is with mother.
with the mother.
Child being a minor, his custody is with the mother. Eta pore lekhibe se Bhubaneswar rauchanti seta bile. Yes.
Right, right. The urgent copy tomorrow.
Urgent certified copy as per rules, parties to act upon. The copy obtained from the official website of
Right.
the High Court,
Grateful.
of this court. Press gote pass over achi. Yes. Next. Nahi, orders continue karo. For call kale sita nathile. Continue karantu orders.
Item 11,
Please tell us. I was, since I have filed the amendment only to change the name of the opposite party, the current director. I filed on
Mr. Jyotirmay Gupta for the petitioner. Mr. Prem Kumar Mahanti, additional standing counsel for the opposite party. IA 480 of 2025. It is submitted by Mr. Gupta, Lord Counsel, that he wants to amend the cost title. The petitioner wants to amend the cost title to bring on record the present incumbent director of
secondary
education.
copy of the IV.
The copy of the IA shall be served on the learned additional standing counsel.
I mean, the
He served in the learned additional standing counsel in court today. So, Mahanti, you will allow or you will take further time? Na kaun kari?
It will be allowed.
Copy served. Considering the nature of the prayer, the amendment is allowed. The petitioner shall have the liberty to bring on record the present incumbent director of secondary education. The amended cost title shall be filed within
1 day.
within
two
5 working days.
Only cost title.
ଆପଣ ଆଜି ଦେଲେ ବି ହବ within outer limit ଟା ମୁଁ ପଚାରୁଛି within 2 working days by serving upon serving copy thereof on the learned additional standing counsel
Cost title.
registered to do the needful. Yes, next.
Simple prayer only, repentation to be disposed of. That is last occasion also you are also be directed to dispose.
ସେ ଆପଣଙ୍କର ଏଥିରେ after remand by the Supreme Court, that matter where they have considered the 4/4/2025 amendment. That ଆପଣଙ୍କ rehabilitation assistance ଆପଣ
None.
Area division.
ସେ instruction ନିଅନ୍ତୁ.
I will take instruction.
ତାହେଲେ ଆପଣ longer period ନିଅନ୍ତୁ, ସେ instruction ନିଅନ୍ତୁ. Within 2 days, the 2 days ହେଇଗଲା, ତାପରେ ଲେଖନ୍ତୁ the learned AC 6 accommodation to obtain instructions.
Compliance file.
List after 3 weeks. 3 weeks. Regarding compliance of the order, instruction regarding compliance of the order. List in the week commencing कर दियंतु. 2/2/2026. Yes, next please.
12,
Oblige.
Yes, please. पढ़े गले. Pass over.
13.
Mr. State Counsel, wherever your parties, I mean, no, you have a genuine point that you don't have to wait for them, but we are passing it over for some time at least. We'll call it at 1 or after a recess.
12-13 we are not party member.
12-13 ନାହାନ୍ତି ଯେ ଯୋଉଥିରେ ନାହାନ୍ତି ଆପଣଙ୍କର ମାନେ ପାସ୍ ଓଭର ହେଇଯାଉଛି.
ଆଜ୍ଞା.
So ଆପଣଙ୍କର
1 o'clock at 1 o'clock pass over में ticket at 1 o'clock. No, at 2
ହେଲେ ଚଳିବ ତ?
ଆଜ୍ଞା.
ଠିକ ଅଛି ତାହେଲେ କଲ୍ କରନ୍ତୁ. 12 ପାସ୍ ଓଭର. Mr. Nayak 13.
13 IA number 27/2026 is filed. That is with
Record ରେ ନାହିଁ.
record nahi. Asu next week.
Mr. Pavitra Kumar Nayak for the petitioner. Madam R. Jena. Madam R. Jenna for the opposite party. The office note put up by the registry indicates that application for condonation of delay not yet filed. It is submitted by the learned. Stop. Stop. It is submitted by the learned counsel for the petitioner that the application has already been filed. Registry shall verify and bring the same number.
27 by
that IA number 27 of 2026. 2026 has been filed. The registry shall do the needful to bring the same on record. Copy served hichi. Copy of the IA shall be served on the learned counsel for the opposite party within 3 working days. Now today aji de debe. In court today. Acha, ठीक है, within 3 working days. Yes. List in the week commencing. 27/1/2026. Okay. I'm sorry, SCR Das, not Pavitra. Mr. SCR Das, Adhikari Chittaranjan Das. SCR Das. Yes, next.
14.
Pass over करते तो देखिए.
15.
Here, Mr. Mahapatra.
Your Lordship, kindly look into the last order, Lordship, 17th of November. In fact,
for stay. Certified copy filed by counsel.
Although the notices on
filed by counsel appellant flag D. Additional document filed by counsel flag C. Additional document 17/11/25. Report regarding compliance of order 17/11 family court Hon'Ble flag E. Seta upon chaunchan देखिए पे.
Lordship.
You are placing which order? 17/11.
Order number 2. Order number 2 dated 17th November 2025. This order.
Memo file है जी.
हाँ, yeah.
You have filed the memo.
हाँ, file memo.
Mark है नहीं हमारा.
आज्ञा.
Memo अच्छी कोटे कौन. Mark है नहीं.
एथिरे ऑनरेबल कोर्ट हेल्ड करछन जे नोटिस इज सफिशिएंट तापरे टुडे और
नहीं मेमोडा कौन फाइल करछन दिस जो कंप्लेंट्स आपण देखिबे
हां
फर्स्ट पैराग्राफ द ऑर्डर इट रेफर्स टू ए मेमो से मेमोडा काई
आज्ञा मेमो ऑलरेडी फाइल हेछि म
पूरा पेपरलेस रे देखु नांती टू हेल्प मी फ्लैग डी बोदे
आज्ञा Yes, sir.
17/11/25 memo.
Okay.
Here.
Yes. This one.
You place that where you have mentioned what is the purpose of filing that memo. Para 2 bode. Para 2 ta place karantu.
That by order number 11 dated 10th of November 2025 passed by the Learned Executing Court at Hon'Ble that in CRP number so and so. It reveals that the remaining amount of rupees of the 50% area dues of rupees 40,000 is received by the petitioner number 1. That is present petition of the petitioner number 1, and the case is posted to 5th of December 2025 for payment of monthly maintenance amount for the month of October 2025 and November 2025. The photostat copy of the order dated 10th of November 2025 is acted as series for kind perusal. Para 3 says that the due payment of monthly maintenance amount for the month of October 2025 and November 2025 have also been reported in the bank account of present applicant number 1 by the present petitioner today, and the respective report slips showing the payment of 20,000 are attached herewith.
Sir, 40 20 ना नहीं total 40 40 plus 20 60 total 40 तार आपण फाइल करचंती ये.
हाँ.
Yes. Go please scroll down. Then there is a draft of
20,000. Let's go.
63,000 ना. Ramora Naik son of बलराम प्रसाद की
नहीं इट ऑन डिमांड ऑफ बलराम प्रसाद
कौन आसी गले
निमा नायक वाइफ ऑफ भ्रमर नायक दिया
एमती कौन ना था डिमांड ड्राफ्ट रे एते लोकंकर केवल तो अकाउंट होल्डर ना रहइबो अपन केते नंबर आइटम धनेश्वर नायक तो ठीक अछि
15 नंबर आइटम है
धनेश्वर वर्सेस भ्रमरवर हु इज भ्रमरवर हाउ दे आर रिलेटेड
लॉर्डशिप इन फैक्ट petitioner is the son
धनेश्वर go by the name so that there will be
धनेश्वर son
Naik of Brahmavara.
Brahmavara Naik. Brahmavara Naik is the father.
Dhaneshwar is son of Brahmavara. Now Dhaneshwar claims money from father.
Father under 128 CRPs.
Okay.
Mother, father are
So,
the
Balaram Prasad क्या ऐसी वाले मजरे? हमारा I think there is some confusion, Mr.
Lordship.
So you अपना check करंतु. Because the court that considered that day the memo was not available.
Oral submission
you have complied that. You have filed that memo. So now I am looking at that memo. So there is some, you check it.
Lordship.
So you take simply adjourn this.
Let's say I will satisfy. Yes, so far,
Brahmara actually son.
Bappa. Brahmavara Naik was Bappa of the petitioner.
Dhaneshwar ki.
Who?
Apna padhantu flag hi jantu hobe. Flag hi page 5.
5.
Page 5. Pehले.
Again.
The counsel for the OP, Subpara.
Again. The counsel for the OP also filed demand draft bearing number so and so amounting rupees 60,500 in favor of Nima Naikas. That is the wife of the Brahmavara Naik, mother.
And don't interrupt.
Again.
Normal padhantu so that there will be less confusion.
Again.
And demand draft so and so in favor of Brahmavara Naik.
The counsel for the OP also filed demand draft bearing number so and so amounting rupees 63,500 in favor of Nima Naik and demand draft bearing number so and so in favor of Brahmavara Naik.
Apna kojun Brahmavara Naik father.
Again. Father.
Brahmavara Naik ko टंका दिया है
Brahmavara Naik को टंका दीटा ड्राफ्ट बना गला
हाँ जी आपण पुओ मागुचंदी टंका बापा कोठु ना बापा मागुचंदी पुओठु
हाँ बापा मां पु देवा पे पुओ को ऑर्डर हेतिला
निमा होचंती मदर ब्रह्मर हेले फादर
बापा
Dhaneshwar is the son
who is the petitioner.
Can you read further? Continue.
Again, amounting rupees 60,500 dated 8th of October 2025 of Eco Bank, which is received by both the petitioners with proper endorsement in the remarks column of the order sheet. A photocopy of these two numbers check to be kept with the case record. Next para, it is submitted by the counsel for the petitioner that the check submitted and the amount of rupees 55,000 earlier paid do not make out the 50% of the area maintenance as on TVC nor their purchase. The counsel for OP submits time to file the remaining amount of the 50% area dues and the regular maintenance amount after 1 month. As such, the case is posted to 10th of November 2025 for payment of the said dues.
Say down on to
10,
11 ne dele kodi seta de diyo.
हाँ
Page 8 C3 आपण को खोले scroll down करंतु.
Again.
Order number 11.
Again. Both parties are present. Counsel for both parties are also present. The learned counsel for petitioner files a petition for payment of maintenance along with area of two petitioners on the ground stated therein. Copy shop on the other side. The remaining amount of the 50% area dues of rupees 14,000 is received by the petitioner 1, which is engrossed in the remark column of the order sheet.
Yes.
Next para. Advocate for the OP files a petition praying for time on the ground secondary. The payer is allowed put up on 5th of December 2025 for payment of monthly maintenance amount for month of October purchase and November purchase. That also in complaint. I have the certified copies with me.
So now what do you want? So you are saying that conditions imposed by the coordinate bench have been complied with. So already the court bench has passed an order of stay.
Order of stay subject to payment and that payment is made. The only thing that today either the party concerned or the advocate concerned should have been paid, appeared with the Hon'Ble Court. But as per the cause list, none has appeared. And in the last order, the 17th of November 2025 order, this Hon'Ble Court is pleased to hold that the notice have been sufficient.
It's better you should serve them through the learned trial court where they're appearing in the.
There, that is the order only. In the last
Where? Kindly find out.
Para 8, Lordship. Para 8 of that last order. Office is directed to communicate a copy of this
No, it
order.
is not there.
Aye.
Notice. Communicate କଥା ପଡିନି.
Note.
Communicate ଟା ଆପଣ ତ ପଢିଲେ ଏବେ. ଆପଣ notice ଟା ସେ court through ରେ serve କରି ଦିଅନ୍ତୁ.
ହଁ କରିଦେବି.
When I asked you, I am saying about the notice. I am not saying about the order.
ନାଇଁ ସେ ଆଜ୍ଞା ଠିକ ଅଛି.
କଣ ଲେଖିଲେ? ଲେଖିନାହାନ୍ତି. So Rajesh Kumar Mahapatra for the petitioner. Opposite party none. The learned counsel for the petitioner was heard at length. He refers to the order dated 17/11/2025. As well as the order dated 23/9/2025 passed by the coordinate bench. Para. It is submitted that while issuing notice in the RPFM number 282 of 2025, in the present RPFM, the upper the RPFM likha hai, in the RPFM, along with the IA 430 of 2025, seeking interim stay. Seeking interim stay of the order impugned or interim stay of the order dated 9/5/2025 passed in CRP number 25 of 2023 by the learned judge, Family Court Hon'Ble. The learned judge, Family Court Hon'Ble. The coordinate bench had imposed conditions for deposit and payment of amount to the respondent father as well as the mother of the petitioner, sir. The learned counsel for the refers to the memo dated 17/11/2025 to submit that the evidence of the payments as directed by the coordinate bench has been made, as would be evident from the demand drafts deposited before the learned court, learned family court, Hon'Ble. It then refers to the order dated 10/2025 and 10/11/2025 to passed by the learned family court Hon'Ble, copy of which is available annexed to the memo, to submit that the conditions imposed by the learned by the coordinate bench have been complied with. This court records satisfaction of the compliance of the conditions and further directs the interim order as directed by this court dated 23/9/2025 shall continue till the next date of hearing. Para. By order dated, the order dated 17/11/2025, the coordinate bench had directed service of copy of the said order on the learned counsel for the OP number 1 and 2.
Not direct. There is no directional decision on that order.
Para 8 पढ़िले आपण नि
Para 8 लॉर्डशिप लिखा है office is directed. Office is directed to communicate.
Correct. I'm contacting.
Directed कल मुझे कल मत से कॉल ले.
ठीक अछि त.
More to me नहीं. मु बोल.
मु आपण मी कहनी कि यू कहनी. मी यू आपण कहउछंती. Only directed service of the year. Stop. It is submitted that the registry has already communicated the said order and it has been served with the on the learned counsel for the OP number 1 and 2.
Lordship.
Say 1 and 2 आपको पचारते हैं डॉट की होने 1 and 2 पारा पर जो रिक्विजिट्स गुड़ा का फाइल करते ले अच्छी ना नहीं सर फेरी नहीं
नहीं जहाँ ऑर्डर ऑलरेडी सफिशिएंट
नहीं नोटिस जो इश्यू हैला आपण कोन कोले ता पर सेटा मते कोन
नोटिस लॉर्डशिप पारा 3 लिखा होची इन व्यू ऑफ द ऑफिस सर्विस ऑफ नोटिस ऑन द अपर पार्ट 1 2 3 4 आर हेल्ड टू बी सफिशिएंट इट इज ऑफिस नोट पारा 3 रे लिखा है जी सी ऑर्डर रो 17
कोटा पर नोटिस ऑर्डर ही नहीं
बट
आपण ऑफिस तो देखु ना से पेपरलेस रे देखंतु पहले ऑफिस नोट क्लिक करंतु सेकंड पेज को जानतु रोमन 4
रोमन अगेन
कौन लिखा है
on sub notice in admission stay matter received from R3 with only R3 with postal demand long absent on claim
सर्वर हुंतु नहीं सेरा प्रॉब्लम होबो रोमन 5 पढंतु
again with neither AD nor on sub notice received from R1 2 4 5 regarding this postal tracking reports are at flag 1 2 4 5 with remark item delivered at Bonpal SO
से तापर ताकू मागले कहउछन जे we cannot give who received it we can only say delivered we try to actually extrapolate further so आपण जोटा कहउछे जे sufficiency record हेछि बोले कोटा नोटिस सेटा
3 रे ऑनर कोड कहउछन एई से ऑर्डर ता रे 17 11 ऑर्डर रे से कहउछे इन व्यू ऑफ द ऑफिस नोट
को जगह रे कहउछन पैराग्राफ
पारा 3 लर्स मु पढ दोछ पारा 3 टा in view of the
there is no note regarding service of notice
से लेकुछन
आपण सेटा गाइड करिया कथा because they are not appearing
they are
you should have guided the court you should have now it is available you should go by the records though the coordinate bench has taken note of the office notes by order dated 17/11/2025 to observe that notices shall be taken shall be treated to be sufficient to ensure service of notice it is directed copy of the appeal memo copy of the petition along with requisites shall be filed in the registry to be forwarded to the learned judge family court who shall further direct service of the notice issued by this court through his office on the learned counsel सेठी के अपेयर करछंती से प्रोसीडिंग टा कते सीआरपी
नंबर दे
25 of 2023 हैला के अपेयर करछंती कोन
प्रेजेंट ओपी 1
कंफ्यूज होंतो नि भूलभाल हे जो
नहीं प्रेजेंट ओपी 1 and 2
3 4 सेठी अपेयर करना
नहीं से पन सन गोटा
ठीक है कोन लिखि appearing for 1 and 2 as well as the opposite parties 1 and 2 in person. The requisites for issuance of notice through the learned court judge family court in CRP number 25 of 2023 shall be filed in the registry of before the registry of this court within 7 days. Within 5 working days. Registry shall do the needful. The learned judge family court Hon'Ble is also requested to send to direct his office to send the proof of delivery, proof of service of notice with the petition to this court to be kept on record. कि समय दियंतु तांको नेक्स्ट डेट केबे जानि छंती
ना सर नो नॉलेज नहीं नेक्स्ट नॉट अछि सर सॉरी मु कई लास्ट आस्तिला नेक्स्ट अछि फेब्रुअरी 7th of February
7th of February गोटे वीक पर रखु गोटे दुई पर रख परिले 7th ले 7th होची सैटरडे लिस्ट इन द वीक कमिंग 16 कर दे सो आइगा 16 2 20 26
That's grateful.
Anything else? Out of
Then,
the interim order is made absolute. The interim order passed
on 23rd 9.
on 23rd 9 shall continue up in the next date of hearing. The petitioner shall comply with the conditions. Shall continue to comply with the condition
That I am continuing.
regarding payment of monthly maintenance.
That's
Yes, next.
grateful.
16.
Adjournment ଚାହୁଁଛନ୍ତି?
adjournment ଚାହୁଁନି ଯେ objection copy of objection ଏପର୍ଯ୍ୟନ୍ତ ମିଳିନାହିଁ
You are for
for petitioners.
your name, sir?
My name is Ajit Kumar.
Mr. A.K. Ratha for the appellate.
My lord, in this case, I want 4 weeks time to file objection, my lord. No objection has been
Mr. Prem Kumar Mohanty. Objection to the IA.
Objection to the IA. 3 IA they have filed.
Sir, A.K. Ratha for the appellant petitioner. Sir, IA sange mistake lekhantu. IA so and so. IA is number kontu.
IA number 79 of 2025.
IA number 79, 88, 89. How IA kon?
89, my lord.
IA 79, comma 88, comma 89, 2025. It is submitted by the learned counsel for the learned additional standing counsel for the respondent 1, opposite party, that the objections he may be accommodated to file objection to the IA and stuff. He prays for 4 weeks time. Stop. Accordingly, the matter shall be listed in the week commencing 2/2026. 4 weeks मांगुଛନ୍ତି ଆପଣ 2/2 କେମିତି ହେଲା? 16/2 ହବ। 9/2/2026. What about other respondents, Mr. Ratha? Notice ନେଲେ ନା ନାହିଁ?
Already at the time of filing this appeal.
No one is appearing, sir.
Notice, my lord.
ଆଜ୍ଞା କୋଉ ଅର୍ଡରରେ ନୋଟିସ ଇସ୍ୟୁ ହେଇଥିଲା? ଆପଣ ଯଦି ରିଟ୍ ରେ ଫାଇଲ କରିଛନ୍ତି ଆୱାର୍ଡଟା ତାର ସାର୍ଟିଫାଇଡ କପି ଆଣୁନାହାନ୍ତି କାହିଁ ହାଇକୋର୍ଟରୁ? ତ ଆଇଏ ରେ ବର୍ଷେ ପଳେଇଲାଣି ପେଣ୍ଡିଂ ରହିକି।
Already
କଣ ଅଲରେଡି
certified copy have already been
ଆପଣ
submitted.
ଫାଇଲ କରିଦେଇଛନ୍ତି?
Already.
ଏଠି ଫାଇଲ କରିଛନ୍ତି?
That's
Noting is there.
noting is there.
ସାର୍ଟିଫାଇଡ କପି ଲେଖୁଛନ୍ତି। ସେ ରିଟ୍ ଟା କାହାର ଡିଟରମିନେସନ? ଏଇ କୋର୍ଟର ଜୁସ୍ ଅଛି ରୋଷ୍ଟର? LAA ଅଲଗା, ରିଟ୍ ଅଲଗା। ଆପଣ ରିଟ୍ ଟାକୁ ମିଶେଇ ତ ହବନି ଆପଣ ଯେମିତି
It was
କହୁଛନ୍ତି।
misfiled.
Wrongly filed।
Wrongly misfiled. That's why
ତାହେଲେ ଠିକ ଅଛି।
the limitation
ହଉ ଠିକ
comes
ଅଛି।
to pass.
ସେ ଆପଣ ଡିଫେକ୍ଟ ଯେତେକ କ୍ଲିୟର ହଉ ତାପରେ ଆପଣ
Then again under
So, other respondent ku, my question to you is why you have not taken notice to other respondents though the matter is kept pending? You have to expedite, sir.
already.
So what is your submission on that?
That's simple.
ସେମାନେ objection file କଲା ପରେ notice ନେବେ ନା କଣ? Are they not supposed to know the issue notice? IA ରେ ଲେଖିବେ issue notice in the all the IAs. Dispensing ଟା ଖାଲି ଛାଡ଼ି ଦିଅ। Dispensing କେତେ? You should notice to the respondents 2, 3, and 4. In IA number 79 as well as 88 of 2025.
Within.
Stop. Requisites for issuance of notice by speed post with registration and proof of delivery we filed within 7 working days.
That's
List after SR. Devoted to mention. जो लिस्ट ऑफ ट्रेजर न करिकी awaiting service return of service list on date केबे देचंती
We commencing
the matter shall be listed in the week commencing 9/2/2026. Yes, next.
17.
That DLAA माने diary number.
Yes, right. My lord, this is for temporary exemption of court fee. I have annexed the order passed, annexed to 1.
How much time, sir? How much time you require? What is the office note on that? Whether it can be allowed? Now,
This court has already allowed, my lord, because some appeal, I am also submitting the latest order filed by this order.
No, valuation, just look at this paperless. Order number 1 dated 14/11/2025. Can you read that?
15/11.
Office note रे अच्छी देखिए. Office note को ऊपर को. Order number 1 14/11.
14/11. Order number 1. Order number 1.
बुकमार्क को जानतो बुकमार्क रे क्लिक करंतु बोल्ड अछि ऑर्डर नंबर ता
Yes.
Learned counsel, kindly read that. Can you read it aloud so that what you are reading I can, or I will read it for you.
Learned counsel for the petitioner submitted that the stamp reporter has remarked valuation and court fee payable not furnished in the appeal memo IA filed for exemption of court fee put up for further SR after disposal of the IA. List this diary number before the assigned bench. So this here the submission is the opposite party respondent, my lord. They have filed appeal. We have also filed appeal. In their case, this honorable court has granted temporary exemption for payment of court fee. And
sir, where is that petition?
IA.
Sir, when you were saying their case, which is that case number I want? In their case, court has granted temporary exemption,
yes.
But you are not referring to the case number. That I want.
47 of 25.
Listed.
54, 29.
And 154 of 2019 and 47 of 2025.
File memo?
Yes.
Memo diuntu.
Memo this and another prem.
Just 1 second. Let us go one by one. Yes, another.
2025 रे जो order type letter देखो इटा recent. Okay. 2019 order that has been annexed as annex of 1.
But these are my determination. पण जो तीनटा एले देइचंती सेटा ए बेंच रे आसीबा ना अलगा बेंच
सब ए बेंच रे आसीबा
ना एले से पैरेलल ये रहउछ ना दैट इज अ प्रॉब्लम इफ आई डू नॉट हैव आई कैन नॉट टेक अप एटा कोन कहउचंती
एटा एबे ऑर्डर है एबे आ गोटे केस टेम्पररी appeal from their side and appeals.
But anyway, आपण जदि सेटा करूचंती आपण सेटा आसु सेमान अपियर करंतु आपण 47 टा आज लिस्ट हिची की 54 4 47 they have not been listed, so that is why I suggested that you file the memo. आपण लिखंतु एले
tag
D-L-F-43052.
We have also filed a memo for tagging all the matter.
D-L-F-43052 of 2025. Vijay Bharat Mahapatra जोटा अछि गोटे item 17 the first matter. Your name is not there.
My name is not there, but appear on the next day. They're fine. No.
पण वकालत नावा नाही.
दो फाइल मेमो ऑफ appearance file.
केबे देबे It's submitted by the learned counsel that he shall file the. You are Senapati.
Yes.
Yes, Senapati.
It is submitted by Ms. Shweta Senapati. Shweta Senapati for the appellate. The defect, the land acquisition appeal has been listed as defective in view of non-determination and non-submission of court fee payable. IA number 228 of 2025 has been filed by the appellant petitioner it is submitted by Ms. Senapati that Mr. B. N. Mohanty, learned counsel, shall appear on behalf of the appellants. So Mohanty submits that he is present and he submits that he shall file his okalatnama. Kebe ke din lagibo?
Today
He will file the okalatnama in the registry today. The okalatnama shall be taken on record, scanned copy be updated. Name of Mr. Mohanty shall be reflected in the cause list as well as the case free appearing with learned associates for the appellates. IA 228 of 2025, the IA has been filed exemption, seeking exemption from payment of court fee of rupees 32,769 of 66.
temporary.
But when you have determined it, how the court I can record that it is not determinable.
Not determined.
But it is you have yourself determined it.
We are seeking for enhanced compensation.
So factually both the parties.
After the award was.
So let us see what is happening. Comma 769.66 till disposal of the appeal. It is submitted by the learned counsel for the Mr. Mohanty, learned counsel for the appellant that LWA 47 of 2025, LWA 4 of 2025, and LAA number 54 of 2019, which have been filed and pending consideration before this court, were taken up by the coordinate bench. And the coordinate bench has granted interim order directing exemption of the court fees. She produces one such order dated 27/10/2025.
That is the annexure 1 to the.
Passed in LAA number 47 of 2025. Copy of the order passed in LAA 54 of 2019 has been annexed to the IA. Accordingly, the said appeals shall also be tagged to the present records to be listed together.
Second February fix it.
In the week commencing 2nd February. Second March se fix hai. 22 रे इतना सबसे big. 2nd February fix है अपन जान in the week commencing 2nd February 2026. List in the week commencing 2nd February. Yes. The ST shall do the needful. On your matter in view of the order passed in the connected D-LAA 43052 of 2025. The matter shall be listed in the week commencing 2nd February 2026. The memo filed by Learned Counsel, Ms. Senapati, giving the list of cases connected to the present appeal, shall be taken on record, scanned copy be updated. Yes, next.
18.
So, my lord, I have filed an IA number 21637 of 2025 for extension of time to comply with the order dated 10/10/2025. The lordship directed me to file the appeal within 4 weeks. But as the petitioner was at our station, he could not prefer the appeal within time. Lordship, kindly peruse the order dated
4 weeks from?
4 weeks from the date of
10/25.
yes, paragraph 5 of the
IA लिखिबे 21637 of 2025. The appellant होचंदी Mr. Alok Kumar Ponda for the appellant petitioner. Mr. Prem Kumar Mahanti, additional standing counsel for the respondent opposite party. Copy serve करचंदी?
yes.
Yes.
Copy of the IA has been served on the learned counsel for the respondent. The hard learned counsel for the appellant petitioner. Stuff. The IA has been filed in the disposed of writ petition WPC number 27191 of 2025, disposed of on 10/10/2025. Stop. It is submitted that in terms of the order dated, the said order dated 10/10/2025, the petitioner was to file the appeal before the
sub-collector.
Before the sub-collector.
Appellate authority. It is mentioned.
Appellate authority under the Odisha Survey Settlement Act and Rules, read with mutation manual within 4 weeks. Stuff. Due to personal difficulty, the petitioner has not been able to file the same within 4 weeks from 10/10/2025. तापर फाइल करिकी भी फाइल करना
नहीं से एक्सेप्ट करना तो जेतु टाइम टा एक्सपेक्ट
केबे फाइल करिवे तार
within 2 weeks.
It is submitted by Mr. Ponda Learned Counsel that after the period of 4 weeks was over, the authorities are not accepting his appeal memo for consideration. Stop. The Learned Additional Standing Counsel in response submits that sufficient time was granted and no further time may be granted. Para. Having had Learned Counsel for the petitioner as well as the Learned Additional Standing Counsel, taking a lenient view, this court grants further 3 weeks time to the petitioner to file the appeal. It is further clarified that no further extension of time shall be granted.
Nice.
So, urgent certified copy as per rules. Parties to act upon production of the website, the copy of the order obtained from the official website.
No.
The IA is disposed of.
Okay.
Pass over dakibe judge. Pass over आरंभ करो आपका नोटिस पूर्व
Pass over item 5.
Challenging Annex 1. The order dated 3/1/25. Lordship, may kindly turn to page 30. The
Sujata Jena for the petitioner. Three-one, you are saying 3/1? 3/1/2021.
3/1/25. Page 30. In granting maintenance, ad interim maintenance of rupees 5,000 in favor of the opposite party, although the same court earlier has rejected her prayer for grant of maintenance in a 125 proceeding. Petitioner is
25, 24, 125 and 24 are different proceedings.
that is true, but question is, my lord.
So minor child.
My lord, child. So far as child is concerned, I am paying 6,000.
So you deposit that amount.
My lord, may I submit? My lord, petitioner is a diploma holder in pharmacy. He is working in a pharmacy, in a shop, medicine shop. Whereas The opposite party is a sub-inspector of police.
You seek maintenance, no difficulty.
No, that is
54 and 25 are gender neutral.
wait, that is true. I
No
have
difficulty
said-
there.
No, you're-
You see the wife working as a,
I am-
say superintendent of police, I have forgotten what you said, superintendent of police, that doesn't deprive her that she will not get any maintenance from the husband because of her job.
No,
The law has not evolved like that.
no, not like that. But under section 24,
Suppose you want maintenance from your wife, you file 24, but you can't complain that since the wife will be awarded, cannot be awarded maintenance.
no, I am not there. My lord, my submission before your lordship is that
This attitude of not paying maintenance in somehow or the other and frustrating the decree pastor, and where you have taken that stand in the order, in your statement. I cannot say that now he is a pharmacist and she is a inspector or whatever you are saying.
getting 8,000 rupees per month.
Whatever that you have to.
Section 24, my lord.
Kindly look at the order, page 30.
Yes. My lord, it is spelled out from the petition.
Yes.
The petition number 1 is the legally married wife and 2 is the minor daughter of the opposite party. And marriage between the petition number 1 and the opposite party was solemnized on 13/12/15 as per Hindu rites and custom in presence of family members, friends and relatives of both, and they were blessed with a girl child on 29/10/16. And the monthly education expenses of the child is more than 8,000 per month. In her petition for payment of interim maintenance in the criminal proceeding number 3 of 21, the opposite party has been directed to pay an amount of rupees 6,000 per month to the minor child, and her prayer for self-maintenance was turned down. The opposite party is having a medicine store in the name and style of Mahima Medicine Store, so-and-so, earning so-and-so per month, apart from earning so-and-so per. The opposite party has filed his objection challenging the maintainability of the case, wherein it has been mentioned that the petition has been filed only to harass him, and the petition number 1 has a tendency to file different petition against him. It is further submitted that the petition number 1 wife is a highly qualified lady and she was working as SI of police, but due to her mischievous act, she became jobless and now she is practicing as a lawyer and getting handsome salary, and she is capable of maintaining her and the child. And he is
The
also...
court has considered, madam.
My lord?
Court has considered.
Yes.
So that then can you read further? Can you read further? So since you said that the court has taken
My
notice,
lord, she
so
has...
can you read further? Complete it.
Yes.
Let us complete it.
She is capable of maintaining herself and the child, and he is also paying the interim amount passed in criminal proceeding number so-and-so. That apart, in DV proceeding number so-and-so, he had been directed to pay rupees 12,500 per month to the petitioner, and he has challenged the said order before the higher forum, and he has now no source of income and he has to depend upon the others for his sustenance, and so the petitioners are not entitled to the relief claim. The object of the provision of section 24 of the Hindu Marriage Act is to prevent vagrancy and ensure that an indigent litigant is not handicapped in pursuing his or her case due to want of money. It appears from the disclosure of statement of the petitioner number 1 wife that she is 31 years old and her educational qualification is matriculation. Well, this is wrong. Their date of...
Wrong or right, the court has not said anything, so don't take exception. We will interim petition.
Yes, your lordship has said.
Can you read further?
Yes, I am reading further. That marriage is so and so, however, the date of separation has left blank. She has admitted about the passing of order for payment of rupees 6,000 per month in favor of the child in criminal proceeding number so and so, and 12,500 per month in their favor in CMC number so and so. Her monthly expenditure is about 45,000. She has mentioned her monthly income as nil in her statement. According to her, the opposite party is earning more than 1 lakh rupee from her medicine store. It appears from the disclosure of statement of the opposite party husband that he is aged about 35 years and his education qualification is the farmer. Their date of marriage is 13/12/15, and since 25/8/18 they are staying separately. He has left blank about his monthly expenditure. He has mentioned his monthly income as rupees 8,000 as he is working as a salesman in a medicine store. However, he has not mentioned anything regarding the amount of income of the petition number 1, nor has filed any document in that regard. actual income and liabilities of the party shall be unraveled at trial after taking evidence, and it would be helpful to arrive at a right conclusion. During pendency of the aforesaid proceeding, the petitioner has come up with the petition praying for interim maintenance as she is in immediate need of financial assistance for her sustenance. In his objection, the opposite party has categorically mentioned that the petition number 1 is now jobless, and according to the petition number 1, her educational qualification is matriculation, as mentioned in her disclosure statement of asset and liabilities. It is not understood as to how she was selected for SI of police having such qualification. Be that as it may, the opposite party has been directed to pay rupees 12,500 per month to the petitioners in CNC number so and so, and he has challenged the said order before the higher court. However, the opposite party, being the husband of the petition number 1, he has a moral obligation to.
Madam, very fair order. Very fair order. At least the court should not have reduced the other amount. 12,500 you are not paying.
My lord, 12,000.
Kindly listen. Kindly allow me to complete. So 12,500 you have fairly stated. You have not stated that you are paying. So you have fair on that account. So what the court has done simply at this stage interim direction 12,500 they have reduced to 6,000. So very fair order. You deposit letters issue notice if you want.
My submission before your lordship kindly bear with me.
Please.
My lord,
already what I have been doing since last morning. Around I started bearing with you for called you 4 times.
That is the way of.
And for the last no. You are not following. I have been passing it over since around 10:45 or like
yes,
that.
that is true, because I am.
Correct. So we still you are saying that my lord may bear with me.
So way of submission we have to do.
Okay. So that is the response I have to develop.
Being a lawyer, that is the way of submission.
So that is being a judge, I have to develop that response also. And nothing wrong factually. Absolutely no factual. You can ask anyone.
My lord, my submission before your lordship is that in the meantime, she has.
No, interim stage, the problem is that the court should not determine these things.
That is true.
There is a possibility, madam, that there is a possibility, esteemed counsel, there is a possibility that you are not liable to pay any maintenance also. But let us not prejudge it. That will not inure to your benefit also.
No,
the husband does, and one like you said that she is a matriculated is falsehood. And D farm working as a salesman is a blatant lie.
My lord,
if you apply those standards.
Because
D farm is the only person who can get a license for medicine shop.
That is true.
So they will sit at home, the medicine shop will operate.
No, you are.
Please appreciate. You go to any shop nearby, no one will find that B farm or D farm because they are too busy persons.
They are busy persons.
They are retired. Either they are retired or they are getting their operating. Their license is the only certificate required to open a shop. So they will never work as a salesman.
Wait.
If he is a salesman, then it has to be 1 lakh.
My lord,
medicine shop earning less than 1 lakh per month in a conservative estimate. In today's price.
As a matter of fact, he is having.
Your instruction has to be treated prima facie because court has very clearly said that it is to be determined on basis of evidence. But since 12,500 has been determined by the DV court, so that determination this court has reduced to 6,000.
A different point. My submission before your lordship is that Section 24, why it has been enacted? It has been enacted to only to see that either of the party should not be put to any distress condition.
You can read 24, no
yes,
difficult.
24.
Read 24.
My lord, 24 I have stated in short.
No.
Yes.
How can we truncate a statutory provision?
Your lordship may kindly see. ମୋ ପାଖେ ବହି ନାହିଁ।
ଦେଇଦିଅନ୍ତୁ। ଆପଣ ଖଣ୍ଡେ ବହି ରଖିଦିଅନ୍ତୁ। ଅଛି।
Section 24, my lord, the lordship got it.
Please.
Wherein any proceeding under this act, it appears to the court.
Kindly mark the word it appears. Yes, this text.
It appears to the court that either the wife or the husband, as the case may be, has no independent income sufficient for her or his support, and the necessary expenses of the proceeding, it may, on the application of the wife or the husband, order the respondent to pay to the petitioner the expenses of the proceeding and monthly during the proceeding such sum as having regard to the petitioner's own income and the income of the respondent, it may seem to the court to be reasonable. My submission before
Can you read further, provided that
the application for the payment of expenses of the proceeding and such monthly sum during the proceeding shall, as far as possible, be disposed of within 60 days from the date of service of the notice on the wife or husband.
So 60 days time is there.
Yes.
And it has to appeal to the court. It can't base because 24 is a very preliminary stage.
Yes.
Nothing is there on record. You say she is a inspector, sub-inspector. So sub-inspector is a postgraduate engagement, and the court has given a finding that she has lost her job. For what reasons we do not know. The other part is that the other part is that the most striking aspect is that the one court has granted 12,500.
My lord, 12,500.
If you are paying 12,500, then fair enough. Because you have challenged it, you are not paying it.
No, I am challenged it before this honorable court,
Correct.
which is pending.
Correct.
And the honorable court has directed that since I am paying rupees 6,000 to the minor child, so right now, as on date, no order has been passed so far as that aspect is concerned.
Fair enough.
But as far
So
as
12,500 is reduced to 6,000.
6,000, your lordship may kindly that.
If your stand is that before the appellate court, in the coordinate bench of this court or the division bench,
Revision.
whatever, before the revision court, you have deposited certain amount 12,500, then then I have to consider it.
No. So far as only 6,000, so far as minor.
12,500 is challenged.
Yes.
So the court has directed you not to pay anything.
Right now,
So that is a ground against you to not to grant any further maintenance. Suppose you are paying that amount, then I will consider.
My submission is otherwise. If your lordship may kindly, my lord, consider this case. Right now, she has been reinstated in service.
Whatever you see, for benefit of me and benefit of the court and for the petitioner, you have read 24. You file 24. What is the difficulty?
My lord.
Being a pauper, meeting difficult to make your ends meet, you file 24 petition.
My 24 petition has been rejected.
So we file it. So challenge that. You challenge that petition on 24.
Another prayer I am happy.
So what you do, you give that 6,000. It is less than 6,000, 12,500.
6,000, my lord, I am unable to
So
pay.
till that year, of course. So that will be considered because you have not allowed the court. This is the difficulty.
Only 1 month.
Whenever I said that then you interjected. Till they appear, you continue paying 6,000 without prejudice to your rights and contentions. Till they appear, then you renew your prayer so that at least they can be heard on this.
Your lordship, I am suggesting 6,000 for a month.
No, till they appear. Let us see.
My lord, I am
So
on
the order is dated. The court. You see, the
125.
court should not have reduced that 12,000. Court should have asked you that what order has been passed in that 12,500.
My lord,
Because 12,500 is executable. The High Court has not stated that. High Court simply issued notice. And the High Court has in its wisdom,
the order has been stayed.
the revision order, it has been stayed.
Execution has been stayed.
So if it has been stayed and without any deposit, how this court will again stay it further the 6,000?
My lord, 6,000, it is in another proceeding.
Correct. That is the reason I am saying if 12,500 you are not paying due to stay obtained from this court, 6,000 I will not stay.
Here, 5,000 has been
Pursuant to 3/1/2025, you deposit
5,000, not 6,000.
6,000.
5,000 has been awarded. Your lordship may kindly.
Yes, sorry. Se ଆପଣଙ୍କର 5,000 6,000 ଆପଣ ଝିଅକୁ ଦଉଛନ୍ତି ଆପଣ 5,000 ଡିପୋଜିଟ୍ କରନ୍ତୁ
5,000 ଟଙ୍କା ମୁଁ ଡିପୋଜିଟ୍ କରିଦେବି
କରିଦିଅନ୍ତୁ କରିକି ଆସନ୍ତୁ
5,000
ଆପଣଙ୍କର ଯୋଉ ଆପଣ ବି ଯୋଉ 1 month କହୁନାହାନ୍ତି କି that is effectively 4 weeks କାହିଁକି ନା ଆପଣଙ୍କ 3/1 ରେ ଅର୍ଡରଟା ହେଇଛି
3/25
ହଁ so very recent order you give that
recent order 1 year
I'm sorry so then you have to deposit 60,000
ନା ମୁଁ କରିପାରିବିନି ତାହେଲେ ହେଇପାରିବନି my lord
ଆପଣ 12,500 କେବେ ଷ୍ଟେ କଲେ କେବେ ଫାଇଲ ଚ୍ୟାଲେଞ୍ଜ କଲେ
ମାନେ ମୁଁ ଡେଟଟା ନାହିଁ
ଅର୍ଡର
ଅର୍ଡରଟା ମୁଁ 2024 ରେ ଫାଇଲ କରିକି ତାକୁ ଷ୍ଟେ କରିଛୁ।
So 25 ରେ it is perfect order. I will not stay this.
Your lord, then I am having another prayer. Your
ଆପଣ କିଛି ନହେଲେ ଆପଣ at least pay some amount, but not 5,000. It is a pittance.
Then
Initially I was thinking it is a 26 order. I got myself, so it's a 25 order. You rightly said.
My lord, may I suggest one thing? Your lordship may target it.
No discrimination. Because
20, the matter.
Maybe 2020 or 2010, I will not target matters discriminating other litigants.
There is
Gross discrimination of other litigants where the superior court, is it that this is the only case pending before the trial court?
3 to 4 cases are pending.
Not other lawyers, all the lawyers sitting here now.
So
that should not be.
But 2020 matter.
It has been discussed by the Supreme Court.
My lord, that is I have.
You see, let him not pay. He is surviving without paying. There is no execution. 12,500 has been stayed. So the wife's interest has to be looked as far as 24 is concerned.
So may kindly see the order sheet. I have annexed the entire order sheet.
Sir, I have seen that.
And
When you started, when I pointed you out the order to read, so obviously after reading that only I suggested it.
They have taken they are taking time. They are taking.
You ensure that the matter proceeds and the matter is allowed in your favor. Taking time is a defense. When you are appearing for the wife, you are taking time. So it is a legal strategy. The court you see, somebody taking time is a legal strategy.
Matter is examination has already.
You file a petition.
Declared.
You file a petition for expunging written statement. There are provisions. When the petition appears and the respondent doesn't appear, the CPC has a chapter. You do that.
She is
But let us not
referring the matter, she has been examined in chief.
Instead of getting an order from here, in that proceeding, you file your petition.
Your lordship may kindly consider that she has been examined in chief. Cross-examination declined. She didn't appear. For which it was closed.
You file it. You see, I cannot become the family judge. As a lawyer, you have to educate the court to proceed in the matter. You file your petition.
Petition we have filed.
So ask the court to pass a order. You challenge that. That's a different thing. I cannot predicate that this will happen in so and so proceeding. So you take it up out of turn of compared to other cases.
May I suggest?
You take adjournment. If you want this matter to be taken up, you deposit some amount, not this way.
Your lordship may keep it to next week.
Correct. I mean, maybe 2 weeks or whatever time you.
1 week after. 1 week after. Your lordship may keep it to 1 week after.
The matter was passed over and taken up. I will pass that order after recess since it is already time. Yes. No, not necessary. Because you want 2 week କହିଦିଅନ୍ତୁ ସେଟା ହେଇଯିବ.
ଆଜ୍ଞା
ଆପଣ 2 week ରେ ଆସିଲେ ବୋଧେ sir.
ଗୋଟେ week ପରେ
12th ଟା 19th ନା 26 27
19th କରନ୍ତୁ.
19th week commencing 19th ହେଲେ.
Oh bless.
Yes. Anyone mentioning any matter in the for admission? That's okay. Yes, next. Rest of the matters after recess. कौन लिखते appearance लिखते taken up. Initially passed on and taken up. Stop. The petitioner husband is before this court challenging the order dated 3/1/2025 passed by the learned judge family court Bhubaneswar at Khurda in IA number 26 of 2024 arising out of CP number 246 of 2020. The said IA was filed by the wife and the child represented through her mother. Seeking maintenance under section 24 of the Hindu Marriage Act during pendency of the CP. Having heard the learned counsel for the petitioner for some time, she seeks accommodation. Accordingly, the matter shall be listed. Kebe date korthile? In the week commencing? In the week commencing 19/2 19/1 na? Inte etin to jainatila? Kon kale? 19/1 से 1 week कहले ना आपण ताको को फेब्रुआरी केमते हेगला पण आउ को जेडे पासओवर मैटर तो मिसी गला ओडे का धरे 19/1 we commencing 19th January 2026. Right. Yes, next.
Pasover item A.
None appears for the petitioner. Though the matter is called thrice over. Once when it reached, again thereafter, after some time, again thereafter, after an hour, and for the third time, after resumption of the proceeding, post lunch stops. The matter is adjourned, granting liberty to the petitioner to grant further opportunity. The matter is adjourned to be listed on the week commencing 2/2/20 ଆପଣ ଯୋଉଟା ଆପିୟର କରୁନାହାନ୍ତି ନେକ୍ସଟ ୱିକ୍ ଆଣିବେ ନା ନାଇଁ ଲମ୍ବା ଆଡଜର୍ଟମେଣ୍ଟ ଦେବେ ଠିକ ଅଛି 2/2/2024
Item 12.
सेम ऑर्डर केबे आगे 2/2 सेम पूरा सेम ऑर्डर
14.
12 और 14 आगुर दिथर डाकिथिले ना थर्ड डाकिथिले
दिथर
ଏବେ ଏଟା ଥାର୍ड ଟାଇମ୍ ଡାକୁଛୁ ଆଚ୍ଛା ଠିକ ଅଛି 14 ସେମ୍ ଅର୍ଡର
Nineteenth.
19 ବି ଦିଥର ଡାକିଥିଲେ
ନାଇଁ ସାର୍ ଏଇଟା ଷ୍ଟାଫ୍
ଆଚ୍ଛା ଆପଣ ସିରିୟଲି ଯାଉଛନ୍ତି ଏବେ ସେଟା କହିବେ ନା ଆଉ none appears for the petitioner when the petitioner none Mrs. Umarani Ponda for the respondent none appears for the petitioner when the matter is called to grant of the further opportunity kebe Mrs. Ponda kebe hele habo
February 1st.
February ठीक कल दियो तो
week commencing 2/2
list का in the week commencing 2/2/2024
Item 20.
Mr. Subrata Mishra for the petitioner.
May I please? Lakshmi C. Annexer to State Commission for Women. He has without any jurisdiction has passed the order of maintenance against the wife. Opposite party number 3, Lakshmi C. Annexer 2, page 15.
You are therefore requested kindly to deduct a amount of 8,000 only per month from the monthly salary of Kanucharan Bariko, diarist, and pay the same to his legally married wife, Parvati Barik, towards her treatment as well as day-to-day maintenance of herself and her son. And basing on pursuant to that order, under Annexure 3, EIC Water Resources already deducted.
No, don't argue the matter as if you are arguing the for fresh admission. ଆପଣ ପୁରୁଣା ଅର୍ଡର ଗୁଡା ଦେଖନ୍ତୁ 18 ମସିହାର 7 ବର୍ଷ ପରେ ଫ୍ରେଶ ଆଡମିସନ କଣ?
ଏଟା ଫ୍ରେଶ ଆଡମିସନ ନାହିଁ, ହିୟରିଂ ରେ ଅଛି।
କଣ ଆପଣଙ୍କର
Annexure 2-3 କୁ ପାସ୍
ଲ୍ୟାକ୍ ଅଫ ଜୁରିସଡିକ୍ସନ ତାହେଲେ ଆପଣ ସୁପ୍ରିମ କୋର୍ଟ ଡିସିସନ ଦେଖାନ୍ତୁ।
এটা স্টেট কমিশন ଦେଇଛନ୍ତି, এটা ଆଙ୍କର ମହିଳା କମିଶନଙ୍କର
ଓଡ଼ିଆରେ ବି କହିପାରିବି। ମହିଳା କମିଶନରଙ୍କର ନାହିଁ କୌଣସି ଜୁରିସଡିକ୍ସନ ବୋଲି ନଜିର ଦେଖାନ୍ତୁ, ନଜିର ଉପସ୍ଥାପନ କରନ୍ତୁ।
ଆଜ୍ଞା ନଜିର
ସିଧା ଜବାବ ସୁଆଲ କଲେ କଣ ହବ? ନଜିର ଆଣନ୍ତୁ।
ଫ୍ୟାମିଲି କୋର୍ଟ ଅଲରେଡି ଆୱାର୍ଡେଡ ଇଣ୍ଟରିମ୍ ମେଣ୍ଟେନାନ୍ସ ଆଇ ହାଭ୍ ଫାଇଲ୍ଡ ଦି ମିସ୍ କେସ୍।
ଆରେ ସେଟା ମତେ ମୁଁ କ୍ୱେଶ୍ଚିନ ଗୋଟେ ଆଡେ ଆପଣ ଗୋଟେ ଉତ୍ତର ଯୁକ୍ତି ଉପସ୍ଥାପନ କରୁଛନ୍ତି ଯେ ମହିଳା କମିଶନରଙ୍କର କ୍ଷମତା ନାହିଁ। ନଜିର ଆଣନ୍ତୁ। ଆପଣ ତ ଡିସାଇଡ୍ କରିବେନି କ୍ଷମତା। ନଜିର ଆଣନ୍ତୁ।
ଆକ୍ଟ ଆଣ୍ଡ ରୁଲ ଦେଖନ୍ତୁ, ଆକ୍ଟ ଆଣ୍ଡ ରୁଲରେ ତାଙ୍କର ପାୱାର ନାହିଁ।
ଏଇଟା ଆପଣ କହିଲେ ମୁଁ ତ ଆକ୍ଟରେ ପାୱାର ନାହିଁ ବୋଲି, ସେ ଆପଣଙ୍କର ସବୁଥିରେ ରୁଲ କ୍ୟାନ୍ ବି ଇଣ୍ଟରପ୍ରିଟେଡ, ସେ ଯୋଉ ଅର୍ ସିମିଲାର ଅର୍ଡର ଯୋଉ ଥାଏ ସେ ପ୍ରୋଭିଜନରେ। ଆପଣ ଟିକେ ପରିଶ୍ରମ କରନ୍ତୁ, କେସରେ ପଢନ୍ତୁ, ନଜିର କଣ ଅଛି ଉଚ୍ଚ ଅଦାଲତ ଏବଂ ସର୍ବୋଚ୍ଚ ଅଦାଲତରେ ଆଣନ୍ତୁ। କାହିଁକି ନା ଆପଣଙ୍କର ମହିଳା କମିଶନରଙ୍କର କାମ ହେଲା ମହିଳା ମାନଙ୍କର ଦୁଃଖ ଦୁର୍ଦ୍ଦଶା ବୁଝିବା। ବିବାହିତ ମହିଳା ନ ପାଇବା ପଇସା ଗୋଟେ ଦୁଃଖ, ତାଙ୍କର ଦୁର୍ଦ୍ଦଶା ମଧ୍ୟ ଅତି ଦୁର୍ଦ୍ଦଶା।
ପଇସା
ଆପଣ ଯୋଉ ଜୁରିସଡିକ୍ସନ କହୁଛନ୍ତି ମହିଳା କମିଶନରଙ୍କ ମହିଳାମାନଙ୍କ ବିଷୟରେ ବିଚାର କରିବାର କ୍ଷମତା ନାହିଁ, ତାଙ୍କ ଦୁଃଖ ଦୁର୍ଦ୍ଦଶା ବୁଝିବାର ନାହିଁ
କରିବା ପାଇଁ ତାଙ୍କର ଆକ୍ଟ ଆଣ୍ଡ ରୁଲରେ ତାଙ୍କର କୌଣସି ପାୱାର ଡିଫାଇଣ୍ଡ ହେଇନି।
ଆପଣ ସେଟା କେତେ ଥର କହିବେ? ଆପଣଙ୍କୁ ତ ସେଥିପାଇଁ ଏଇଟା ପ୍ରଥମ ଥର ପାଇଁ ହେଇନି କେସ୍। ମହିଳା କମିଶନର କାହାକୁ ଦବା, ଆପଣଙ୍କର ମେଣ୍ଟେନାନ୍ସ ଦବା, ଏଟା ପ୍ରଥମ ଥର ପାଇଁ ଓଡିଶାରେ ହେଇନି। ଏଇଟା ଯେବେଠୁ ମହିଳା କମିଶନ ହେଲେଣି ବହୁତ ଥର ଦେଲେଣି। ତ ଆପଣ ସେଥିପାଇଁ ପଢନ୍ତୁ, ନଜିର ଉପସ୍ଥାପନ କରନ୍ତୁ, ଯୁକ୍ତି ତାପରେ କରନ୍ତୁ। ୟୋର ପଏଣ୍ଟ ଇଜ ୱେଲ୍ ଟେକେନ୍। ନହେଲେ ତ ମୁଁ ନ ଶୁଣିକି କହନ୍ତି ଯେ ନା ନୋ ମେରିଟ୍, ଆପଣଙ୍କୁ ତ ଶୁଣୁଛି କାହିଁକି ତାହେଲେ? show some precedents or case law on this where this has been dealt with. କାରଣ ଆପଣଙ୍କର ଆପଣ ସେ ମହିଳା କମିଶନ ଆକ୍ଟଟା କୋଉଥିରେ ଅଛି? ଆମର ଭଲ୍ୟୁମ କୋଉଥିରେ ଅଛି? ଷ୍ଟେଟ ଆକ୍ଟ ନା ଇଏ ଆକ୍ଟ? ଷ୍ଟେଟ ଆକ୍ଟ। ଆଣନ୍ତୁ, ଭଲ୍ୟୁମ ଆଣନ୍ତୁ। ବହି ପରେ ପ୍ରସ୍ତୁତ ଆପଣ ନା ଖାଲି ଆପଣ ହସିବେ? ଆପଣ ବି ଉତ୍ପୀଡ଼ନ କରୁଛନ୍ତି, ବୁଝିଲେ? ଷ୍ଟେଟ କମିଶନ ଫର ଓମେନ୍ ଆକ୍ଟ 1993 सीटा देखिए से पड़ा गला से इंडेक्स कहीं
सेक्शन 10(1)(c)
ଆପଣ ନଜିର ପାଇଛନ୍ତି କି, ପଢିଛନ୍ତି କି କିଛି ପଢାପଢି କରିଛନ୍ତି ନା ନାଇଁ? ଆପଣ ତ କହୁଛନ୍ତି
କଲେକ୍ସନ କରିବି ନା,
ସେ ତାହେଲେ ଆର୍ଗୁମେଣ୍ଟ କରନ୍ତୁନି। ମୁଁ ଦେଖିବାକୁ ଚାହିଁବି ଯେ ମହିଳା କମିଶନ ଦୁଃଖ ଦୁର୍ଦ୍ଦଶା ବୁଝିବେ କି ନାହିଁ ବୋଲି ଗୋଟେ ଦେବି ନା, ଗୋଟେ ଜଜମେଣ୍ଟ ଦେବି।
ଆଜ୍ଞା
ସେଇଟା ମୋ ଜଜମେଣ୍ଟ, ତାପରେ ମିଷ୍ଟର ମିଶ୍ର ନେକ୍ସଟ କେସରେ ସାଇଡ୍ କରିବେ, ସେ ଆପିୟର କରିବେ ସ୍ୱାମୀଙ୍କ ତରଫରୁ। ସେଟା ବି ଆପଣ ବୁଝିବା ଦରକାର। ସୁବ୍ରତ ମିଶ୍ର versus କେକେ ମିଶ୍ର, that will be କେକେ ମିଶ୍ର, ସେଟା ଆପଣ ଡିପେଣ୍ଡ କରିବେ ଯେ ନାଇଁ କ୍ଷମତା ଅଛି। ତ ଆପଣ ମତେ ଦେଖାନ୍ତୁ
ସେକ୍ସନ 10 ଆଉ 1 and 2 ଦୁଇଟା ଅଛି। ସେଠି ଖାଲି ସେ ଷ୍ଟେଟ ଗଭର୍ଣ୍ଣମେଣ୍ଟ କୁ ରେକମେଣ୍ଡ କରିବାର ଅଛି, ସେ ଯୋଉ ଇଲିଗାଲିଟି ହେଇଥିବ କିମ୍ବା ଯାହା ରେମେଡି ଦରକାର ସେ କରିବେ।
ସେ ବିଷୟରେ ଆପଣ, ମୁଁ ତ ମହିଳା କମିଶନ ନୁହଁ ନା, ମୋର ରିଟ୍ କୋର୍ଟ, ମୋର ବହୁତ ପାୱାର ଅଛି। ମୁଁ ତାଙ୍କୁ ଡିନ୍ୟୁଟ୍ କରିଦେବି। ଆପଣ ଗୋଟେ ଅଲଗା ଲେଭେଲକୁ ନିଅନ୍ତୁ ଆପଣଙ୍କ ଆର୍ଗୁମେଣ୍ଟ।
ନା ମୁଁ
ଏଇ କଥାଟା ମହିଳା କମିଶନ ଆଜ୍ଞା ଆପଣ ନାଇଁ, ମୋର କିଛି ସବୁ କରିବା ପାଇଁ ମୁଁ ଜାଣିଛି। ଆପଣ ମତେ ନଜିର ଉପସ୍ଥାପନ କରନ୍ତୁ।
ଆଜ୍ଞା
सी रे कमिशन फॉर वुमेन
10(1)(b)(c) and 10(2)
ଗୋଟେ ସେକେଣ୍ଡ, ମୁଁ ତମ ବହିଟା ପାଇଁ କହିଛି। ଏଟା ହଉଛି ଭଲ୍ୟୁମ 17। ଗୋଟେ ସେକେଣ୍ଡ,
only appropriate
ଭଲ୍ୟୁମ 3
ଗଭର୍ଣ୍ଣମେଣ୍ଟ କୁ ସେ
3
ପରେ ଆସେ। ହଁ
Yes, Mr. Mishra,
This is not an order. This is only there for recommending authority. When there was an order and it was not implemented or accepted by the husband, they have enough power to, for that it is set up to see the difficulty of the woman, the married woman.
We should encourage no difficulty.
Sir, move.
ଆପଣ ଦୁଃଖ କହୁଥିଲେ ଏବେ difficulty କହିଲେ. So you
not
also
difficulty.
no
This is
difficulty.
only recommending authority. He is not here. Absolutely, he is correct. But this is not an order. The implement order here is a letter to the employer. You stop it.
So employer has stopped it.
Yes, it was stopped because of there is stay order. It was not implemented.
Oh, ଆପଣ interim order, that's the final order.
Yes, almost he has got the final order.
So say that is why I was requesting you to go through the earlier orders. Interim order is shall pass.
No, this is the final order of the state commission.
Court has passed an order by staying.
Yes.
So SAS stayed it.
Yes.
So I mean, you have got the release at the interim stage.
Interim.
That Mr. KK Mishra is saying.
Yes.
Yes, you will ultimately see the.
They had allotted counsel for the
order dated 10-9.
Yes.
Yes, sorry, 6/4.
6/4/2018.
Yes,
order number 3. Subrat Mishra for the petitioner. Mr. KK Mishra. Upon secretary of Mahila Commission.
I am appearing for it. I am
upon for the commission. So husband government?
No, he is not appearing. Husband, sir, Mr. Mishra is appearing.
I'm sorry, wife
fine. He is not appearing. Mr. DK PK Mahali.
Prasanna Kumar Panda.
PK Mahali.
PK Mahali बोधे इंश्योरेंस केस करती हो PK Mahali.
PK Mahali. It is in good. It is
Mr. What you suggest? I'll dispose it of.
You also may dispose. Because it will become infructuous. It is not realized, and in the meantime, also there is an order from the family court to pay this much.
Copy that.
Additional document they have filed.
Yes. Mr. Subrat Mishra for the. So we did not go into the top issue whether they have power or not.
This is not
in the circumstances the matter will be disposed of in view of the fact that during pendency of the recommendation the matter has been the appropriate orders have been passed by the court of jurisdiction. Competent court.
Before that he has passed the order.
That is what he is saying. His suggestion is that only that during pendency after it was stayed the competent court has passed the order. Subrat Mishra for the petitioner. Mr. PK Mahanti for OP number 2. PK Mahanti AC. Mr. Kishore Kumar Mishra for OP number 1. OP 3 none. Though notice is sufficient on OP number 3 and Lord Counsel Mr. PK Panda and Mr. PK Mahali have entered appearance. But you take your seat, Mr. Mishra. Have entered appearance on behalf of the OP number 3, but none appears when the matter is called. Without awaiting appearance, since that in view of the order that is to be passed today in the writ application, the court is not awaiting appearance of the opposite party number 3. Para. The writ application has been filed challenging the this is a letter, office letter or order or what you can say?
This is an office letter.
Issued the letter issued by the office letter issued by the member Odisha State Commission for Women dated 3/6/2017. Dated 3/6/2017 issued on 6/6/2017 to the OP number 2. For deducting monthly maintenance amount at rupees 8,000 per month from the monthly salary from the salary of the appellant, who was then working as a diarist in the establishment of the OP number 2 authority. It is submitted by the learned counsel for the petitioner that the State Commission for Women doesn't have any authority to pass such order. He refers to the Odisha State Commission for Women Act 1993 and the rules 2006 to submit that such order directing deduction of the salary, the deduction of a portion from the salary is inconsistent with the powers conferred by the statute and the rules. In response, the learned counsel, Mr. K.K. Misra, appearing for the SCW, OSCW, OP number 1, submits that the letter is only a recommendatory order. While issuing notice by order dated 6/4/2018, while notice recommendatory order and
recommendatory in nature, not order.
The order passed by the order dated so and so passed by the OSCW is recommendatory in nature, and it was open for the authority to take a decision on the said recommendation.
Already deducted. Annexer for the 2 months deducting the account.
It is in response. It is submitted by the learned counsel for the petitioner that the salary, a component of the salary at the rate of 8,000 per month was deducted for 2 months and deposited, as would be evident from the order dated 5/2/2018 passed by the OP number 2. It is agreed at the bar that in the meanwhile, during subsistence of the said order issued on 6/6 मध्ये ना, जो date लिखी है
6/6/7.
हाँ, 6/6.
6/6/17.
A competent court has passed order. Court सेटा अच्छी पहले.
Annexer 2 competent court order नहीं. Annexer 6.
Annexer 6 6 additional affidavit.
They're not separate order.
Learned Judge, Family Court, Bhubaneswar, by order dated 13/9/2017, in IA number 75, in IA number 75 or 73, देखिए 75 of 2017, arising out of CP number 686 of 2016. Under section 24 of the Hindu Marriage Act, has passed the following order. Quote कर देवे page 4 रे अच्छी annexer रे टा अच्छी 6 annexer 6. Opposite party husband to neki within 2 months पर्यंत. It is stated by the learned counsel for the petitioner that petitioner husband in the writ application has also complied with the order dated family order dated 13/9/2017 passed by the learned judge, Family Court, Bhubaneswar, for payment of maintenance at the rate of 6,250 per month towards the wife, for the wife, and rupees 3,250 for the son, and litigation expenses for a consolidated sum of rupees 3,000 has been paid. In considered view of this court, after the interim order dated 6/4/2018 was passed, the order passed by the OP number 1, State Commission for Women, has not been further worked out. And in the interim, The matter stands covered by the order passed by the Lord Judge Family Court under Section 24 of the Hindu Marriage Act. Keeping the question of law raised by the learned counsel for the petitioner open, the writ application is disposed of.
16,000 जो कटी से एडजस्ट हुई बंद
No, no. सेटा हेले I'll still आपन नजर मागिबी जोतबे आपन स्ट्रगल करिवे.
That will be decided in
ଆପଣ କେମିତି ମିଷ୍ଟର ମିଶ୍ର ଆପଣଙ୍କୁ ସି immediately the council will say ଆଜ୍ଞା ସେ 8,000 ଦେଇଥିଲେ ଆଉ 10,000 ଦେବେ. Have you marked when you dictated? 6,750 3,250 ହେଲା କେତେ? 10,000 ଆପଣ ଡିଡକ୍ଟ କେତେ ହେଇଛି?
16,000
8,000 ନା 16,000? 8 8 16,000.
एनेक्सर 4 टा देखो
ସହରରେ ଆପଣ ଶୁଣୁନାହାନ୍ତି that's the problem. ଆପଣଙ୍କର ଯୋଉ 10,000 ବର୍ତ୍ତମାନ ମେଣ୍ଟେନାନ୍ସ ଗ୍ରାଣ୍ଟ ହେଇଛି 24 ରେ.
ଆଜ୍ଞା
କେବେ କେତେ ଦିନ ସେ ପାର୍ଟଟା ବି ଆପଣ ସିଓର ନୁହନ୍ତି. ଇନଫ୍ୟାକ୍ଟ ପର୍ପସଫୁଲି ଆଇ ଏମ୍ ନଟ୍ ଏକ୍ସାମିନିଂ. ଆପଣ କେତେ ଦେଲେ କେବେ ଦେଲେ?
नहीं नहीं से
10,000 ହେଲା ଆପଣଙ୍କର ପର ମନ୍ଥ ଆପଣ 8,000 କମ ଅଛି. ମୁଁ କେମିତି ଡାଇରେକ୍ସନ ଦେବି ଯେ ଆପଣ ସେ ରିଫଣ୍ଡ କରିଦିଅନ୍ତୁ କହିବି ତାଙ୍କୁ.
नहीं नहीं से डायरेक्टर लिखिछन जे 16,000 ताको सैलरी रु डिडक्ट हे कि ताको अकाउंट को ट्रांसफर हे.
It is open to
एनेक्सर
this
4
point before the court below.
ଆପଣ ଯଦି ସେଟା ଆଡଜଷ୍ଟ କରିବା ପାଇଁ ଚାହିଁବେ ତାହେଲେ ସେଥିରେ କରିବେ ନା.
ସେଥିରେ କରିବେ.
Correct. Disclosure ପୂର୍ବରୁ ଲାଇନ ଲେଖନ୍ତୁ. The order passed by the Lorded Court, the OP number 2, 1 SCW shall not be given. OP number 1 shall not be given effect to in view of the order dated so and so passed by the Lorded Judge Family Court, having occupied the field since the date se order ta date hochi 13/9/2017. 13/9/2017.
Everywhere it is mentioned as order. My consistent case, it is not an order. Only recommendation, a letter only.
Yes. Letter कर देगा. Order न करी letter कर दे. सबूत. So letter issued by the OP number 1. Sabut. Yes. Yes, Mr. Subrat Mishra. Any further difficulty? এটা নেই জান. হ্যাঁ এটা আপনাদের ଅଛି এটা কেন তাଙ୍କର ଅଛି? ଓ କାଢୁ ନାହାନ୍ତି? Yes.
Item 21.
May I please, Your Lordship?
Yes, please.
Your Lordship, the notice has been sent to the respondents. So it has been made sufficient to the Honorable Court. So for further instruction, I need an adjournment from myself on the behalf of my senior, Your Lordship.
ଆପଣଙ୍କ ନାଁ?
Ranjit Mahapatra, Your Lordship.
Ranjit Mahapatra?
Yes, Your Lordship.
Ranjit Mahapatra on behalf of Jaideep Pal for the appellant. Why no one is appearing? The SETI ASC for the OP number 1 and 4. What can be done? They are not appearing. Instead of arguing the matter, you take instruction, you can take notice afresh. So that you give a fresh lease of life to the litigation. They are not appearing since 2021.
21.
Mr. Barik, look at item 21. There appearance kichhi nahi. No one is appearing for the respondent, but there is no office note in the cause list. It is a daba katha. Pachariben, koi paribeni, but more the impression se daba katha je sitre. Two and 5 returned after valid service. 3 absent unclaimed. So what can be done? You talk to your senior that if whether you can take notice afresh. office note put up by the registry dated 9/7/2025 indicates that notice in admission matter sent to R 215 has been returned after valid service. Undelivered, then comma, undelivered by full stop, undelivered notice received from R3 with postal remark, quote, absent, comma, unclaimed, hence return to sender, quote ends. The matter is adjourned. The learned counsel shall obtain instruction regarding taking notice afresh to the OP number 3. So, in the meanwhile, it seems no one has appeared on behalf of the respondents 2 and 5. You can take another hearing notice like order 47. How much time? 2 weeks,
sir. After one.
The matter is adjourned to be listed in the week commencing. So 1 week coach. The week commencing 19-1-26. Yes, next.
Much applied, not sir.
22. Let's have a look.
Notice not sufficient.
Last order dated 1/12/2025.
Notice returned answered.
Yeah. And the
Just look at
the noting
cause list
in the
if you-
cause list.
you can look at the bigger one, bigger screen. Instead of looking in the mobile phone, you can look at there. Will adjourn it awaiting notice to be, or you take our.
May I pray one thing?
Is he appearing in any court?
This is challenging the interim order under section 24. So far, the 20,000 monthly maintenance is concerned. In fact,
CP is pending.
we are paying.
CP is pending.
CP is pending at the last stage of. In fact, in the meantime.
So why you are just keeping this matter pending here?
No, for that purpose, exactly. I'm saying by that it
Don't
can be
press it.
disposed of. But I was filed this IA for the purpose of, because 20,000 nowadays, since last 1 year, the petitioner husband is suffering and I have given the entire certificate, medical certificate. He is not able to pay 20,000.
Correct.
Somehow or other it is for reduction.
Mr. Mohanty, we have been discussing today. 24 is scope is very limited for the court to examine. Actually.
My learned
Yes, 25 can consider.
Yes.
So if it is at the stage of completion, you should go ahead for completion of the proceeding and pass a order in 25. Or maybe 25 can be lump sum or can be monthly.
They are taking advantage of the same because they are getting 20,000 per month. They want to linger. And in the meantime, most of the evidences has been completed. Can it be targeted by that?
Purposefully, at least I am not targeting because I am conscious that by targeting that creates a situation in a court like Bhubaneswar where other matters are getting less priority.
It is in the progressive phase.
Whenever you must tell the learned, the counsel who is appearing there, that these tactics of adjourning sufficiently now protected in the CPC. He can move petition and let the court handle it.
But at this, it will be disposed of with as expeditiously at least. By that,
yes, I will record your submission.
That can be disposed of.
Yes.
I will pursue this matter there.
Yes.
How to expedite? Because they are in the advantage stage because they are getting 20,000.
It is happening here.
In such a distress
Mr. Mahanti,
condition.
it is happening here also. This court sitting in division also, we have kept the matter, at least the amount in a fixed deposit or in interest bearing account where the wife is not cooperating. Once the amount is
That is what
deposited,
happening
they are
with
not
me.
cooperating. That is happening. That is, you are
And
correct.
in the meantime, around 14 lakhs. So for the area and other part, that I have paid. This is not disputed. And taking that one, they are not also appearing. By that I am suffering.
The learned counsel for the petitioner, Mr. Satyabrata Mahanti, respondent none. It is learned counsel for the petitioner refers to the office note put up by the registry, which indicates the following. This is item 22, no? 22. They submitted that the notices were taken in the address where the respondent, who is the opposite party in the CP, is recorded. Opposite party in the CP number 889 of 2017. In her address recorded in the cost title as well as the statement, address statement. This further submitted that the petitioner husband, who is also the petitioner before the Learned Judge Family Court in the CP 889 of 2017, in due deference to the order, keeps on paying rupees 20,000 towards parental act maintenance under section 24 of the Hindu Marriage Act. Stop. It is further submitted that an amount of rupees about 14 lakhs has already been paid.
I have given the details.
As per the details given in the
annexure.
In the
see that page 10. In a tabular form, I have given page 10.
At page 10 of the petition.
Calculations.
At page 10 sheet of it. In the form of calculation sheet. It is submitted that the matter is at the final stage of evidence and cross-examination. Therefore, in the interest of justice and fair play, the CP should be concluded expeditiously as possible. Having heard learned counsel for the petitioner and in the facts and circumstances of the case, considering the fact that the petitioner has to pay rupees 20,000, which according to the learned counsel, Mr. Mahanti, he is able to satisfy with much difficulty as he is ailing.
And suffering since last 1 year. I have given the medical.
Since last about 1 year. The learned trial court the learned judge family court shall do well to expedite the matter.
And at the same time, I am out of employment.
And make an endeavor to conclude the proceeding. Depending on the number of matters in the board of the learned family court. The parties to the CP are directed to cooperate in early disposal of the matter and shall not seek any unnecessary adjournment before the learned trial court. The copy of this order shall be forwarded to the learned judge family court by the registry of the court. The writ petition is disposed of. Yes.
Three.
To Samir Kumar Mishra for the senior advocate, along with Susrita Sahoo for the petitioner, Mr. Sethi for additional standing counsel for the
May I please, Your Lordship.
OP number 1, 3, 1, 3 to 6. Which appearing for OP2? OCAC kon ki notice hi nahi.
Man, that will not be required. In the sense, they are only an agency who does the computerization work. Ultimate decision with regard to termination and appeal thereof are dealt with by the authorities whom your lordship just now referred to. OCAC is only, they manage the computerized aspect of it. And I will show to your lordship from the record how this computer has played havoc, and in the absence of any physical verification, the license of this petitioner has been terminated. But this petitioner was engaged.
Is it a bar for future engagement or blacklisting or simple termination?
Termination kar dele.
Beyond that, is it a bar for future?
Bar, my lord, maybe because there is a stigma that I have not supplied. I'll show to your lordship there has been no physical verification at all. And they base on that computerized error that I have not done authentication. I have filed documents to show that 99-100% authentication is there for each month, which is sufficient enough, my lord, for the
problem is, can this court examine that as appellate authority findings of fact?
Not. I'll say
so
depending on the face of it.
If you say that this is a bar, then now it swings to that. Mr. Sethi, you obtain instruction that whether it is a bar according to you.
One more thing that
because it's kind of, I am not acceding to the prayer made by the petitioner in the sense that challenge to that engagement, and since PDS is never stopped, it must have been handed over to somebody.
PDS has been handed over, your lordship. I'll show to my.
For future engagement, this shall not be to
not only that, if I can demonstrate from record that there is arbitrariness in exercise of power on the face of it,
That, Mr. Mishra, the scope of judicial review as an appellate authority is very difficult.
I'll never say that your lordship will reappreciate the evidence. Here there is no material at all, I will say. Somebody sitting in computer room and saying that there has been so much of error, there is no physical verification, there is no complaint against me. This is what I beg to point out to your lordship. And when I filed a rejoinder saying that there is no physical verification, no complaint against me, that necessitated a filing of a reply to my rejoinder, which is normally not done by the State Council. And their entire case is based on a computerized report. Whether that will be the basis to terminate or not, that is what I will humbly urge you for lordship for decision. There is no physical verification, no complaint, nothing. And I have explained in my show cause. And if your lordship finds it a perverse on the face of it, that may warrant an interference. Because I am not.
But what about reinstatement?
What
about reinstatement as a dealer? Are you seeking the direction?
If your lordship suppose hypothetically
holds. Let's hypothesize, correct.
Hypothetically holds that no, my termination is bad. Obviously, the consequence they will consider.
Then the person who is now continuing has to be heard.
That part of
because it is not exactly a service matter. It is a tender and contract.
Had it been a service
matter, definitely without hearing him can be. There is a line of decisions where the consequences will follow from in a service matter. It is just possible that the other person may not be
here.
Heard.
It is had it been a case of.
But it is a case of entering into agreement and contract.
Make a distinction. Had it been a case of like a rival consideration and one getting selected, the other man is to be heard. Because if it is set aside, I set in, he gets out. This is not a case of like that. He steps in only because I am not there. So that case possibly an opportunity of hearing may not be required because state is because state is defending their action. And if your lordship quashes it hypothetically, then that termination gets obliterated. So here it is not a case of rival consideration. Suppose in Chatua case, your lordship has seen, there are 3 persons who have applied pursuant to an advertisement. One gets selected and the other
it is similar to Chatua.
So, but there is a distinction here.
Because the reason being that somebody has stepped into your shoes.
Nothing has even till date come from the state side who has stepped into. It's a case of contesting whether my termination is good or bad. That is what I beg to point out. If the state takes the instruction with regard to the consequential aspect of it, namely, suppose your lordship affirms this order, then whether this will be a stigma or not, that part of it my friend may take instruction. But so far as the...
No, I will not affirm. No, I will not put you to that kind of disadvantage. Obviously, I will not affirm, but I will pass a positive order that your continuance in future and further engagement shall not be impacted by this decision. That I will die. I will not affirm.
But this part of
without entering into merits either way.
My lord.
Without affirming or rejecting, that you can say.
My lord. But I will
Because
also
then you will not agree. In case of a plea bargaining, you will not agree that I will affirm the order and send you back. No,
No,
that's
not that way. What I humbly beg to submit on merit also, I will assist.
Yes,
Lord.
yes, Mr.
I
Sethi,
feel
what do you
there is
say?
a case for assistance.
We will start hearing this.
Yes, Lord.
There is a hint to you. Mr. Misra has, maybe you will accept that, suppose there is a possibility of reinstating him or re-engaging him. Reinstatement will invite disengagement of the person who was now engaged. Reinstatement as a dealer. Because he was a dealer, somebody else must be supplying now, or it has been tagged to somebody. Because, but Mr. Misra, with all he seriously says that there is no answer to that. What has happened after he was disengaged, particular dealer was disengaged, there is no answer in your writ petition or in the reply to rejoinder. And second part is that if the court will not express any opinion regarding the findings and simply say that this shall not be a bar for engaging him.
Lordship, we can file for an additional affidavit answering.
Not necessary. You can obtain written instruction, one line instruction that he can be re-engaged.
Lordship.
But he has a serious challenge to the, merits of the case, of the merits of the finding of this particular order where they have disengaged.
Employed the language, these are paper transactions to terminate me, no physical finding. This is what I have employed, subject to, of course, your lordship's kind consideration. We are only sitting at home, paper shows this error, no, nothing, my lord, otherwise. They cannot show a single scrap of material they verified or ever one person even complained, one person.
Counter, they have not written anything in the counter.
Paper transaction, this error is shown. I have filed paper obtained under RTI Act to show that 99%, 100%. So if it is a paper transaction against a paper transaction, whether my termination is justified. So that will be on the face because there is no complaint, nothing, your lordship. They say that we notice certain suspicious transactions. They provide me documents which shows page 28 that it is 99, 99, 99, 100, 100, 97, 100 like that. Percentage of success. And I have explained in my show cause that jo 2-3 janakar hou natla budha loka asperin ta ghare jai korthili and there is a POS system also jo fail matla tam korthili. I have explained that is also not counted to. Simply they say paper shows this, we terminate. So if my friend can take that instruction which your lordship was pleased to observe, but I will also assist your lordship on the merit.
You obtain that instruction. I can't ask somebody that you accept this, but you can take instruction on that. You will also obtain instruction. Yes, Mr. Sethi, so shall I pass an order or you will obtain instruction?
Well, pass an order.
So Samir Kumar Misra लिख ले appearance section. The Anshuman Sethi, additional standing counsel for the P1 3TO26. It is submitted by the learned counsel for the senior advocate, referring to the writ petition, the counter as rejoinder as well as the surrender, SUR surrender. That there is absolutely no material on record to support the action of the authorities in disengaging the petitioner as a
dealer, my lord, of supplying PDS commodities.
FPS.
That is fair price shop.
Sentence last word. As a fair price shop dealer, cancelling his FPS dealership license for Nissanpur village under Analia Gram Panchayat, Bogorai block in the district of Balasore. It is submitted that there is absolutely no complaint against the petitioner. There is no material on record or physical verification to arrive at the conclusion that was arrived by the competent authority while passing the order. Understood? Impugned before the first appeal ku gale.
Maga reiter asli I was relegated to appellate from. I went in appeal. Appellate order also your lordship will see.
Passing the order that was subject matter of challenge before the appellate authority. It is submitted that the appellate authority has also not considered the matter in its proper perspective and confirmed the order passed by the appropriate authority. ଆପଣଙ୍କର ଯୋଉଟା ଅରିଜିନାଲ ଅର୍ଡରଟା କେତେ?
Original order type
13/22
Annex 7.
ଯୋଉଟା ଲେଖିଲେ ଅଥରିଟି ଯୋଉଟା ଲେଖିଲେ 13/22 into bracket Annex 7 to the writ application.
Annex 8 ହଉଛି
appellate order ହଉଛି 23/6/2023 Annex 8 bracket ରେ insert कर at this stage, on being asked by the court, the learned senior advocate responds that the state authority, the learned state council may obtain instruction whether the passing of the order stated, order dated 13/9/2022, subsequently confirmed by order dated 23/6/2023, shall not be in any manner a bar for future engagement of the petitioner and or his reinstatement as a fair price dealer for Dishanpur village. This order is passed without prejudice to the rights and contentions of the parties at this stage. The learned AC has adjournment list in the week commencing.
Shorter date 23 ରୁ ଚାଲିଲାଣି
27 କହୁଛନ୍ତି 27 ହଁ 26 ଛୁଟି 27/1/2023
obliged.
Please, your lordship.
Yes.
Time for the petitioner, my lord. For
You are Mr. Swain. Mr. Ramesh Chandra Swain.
On behalf of Ramesh.
Your name, sir?
Bikram Swain.
Anyone in your chamber has to be Swain. Ramesh Chandra Swain, T. Swain, Bikram Swain. Anyway, Mr. Bikram Swain on behalf for the petitioner. Mrs. Soma Patnaik for the opposite party.
My lord, praying for adjournment, my lord, to
Yes.
reject.
No.
My lord, I have one contention.
What is the case? Always try to make a little bit summation.
My lord,
Yes.
I have challenged the annexure 4, my lord.
Yes.
Annexure 5, my lord. I'm a destitute lady, my lord. My interim application was allowed, my lord, but it was allowed from the date of order, my lord. Your lordship notes, as per Rajni's question, it should be from the date of filing, my lord. And second prayer, my lord, for enhancement of maintenance, my lord. For which
Enhancement of maintenance. You have to challenge the order. It is an interim order, you are saying,
my lord.
24th. So this court has no jurisdiction for enhancement. Enhancement is statutory. Which section? Section 25. So 25, this court has power during appeal. As a single judge, I don't have power of appeal. That is another way of looking at it. But anyway, that's but if you are filing a petition here for the enhancement, you should file that before the trial court, because this is wastage of time of both the courts. This court not having power jurisdiction will keep the matter pending for a corollary purpose, of course, because you are saying that from the date of whether from the date of filing or from the date of order, that you want to argue. Most likely, this is prior to Rajneesh versus Neha pronouncement. I don't know. I'm not sure of the judgment date, but it seems like it was prior. Could be. But the court has assigned reasons for giving from the date of pronouncement. So that also at the interim stage, you have come at the interim stage. Because ultimately, if in the CP is filed by you or the husband, by the wife or the husband.
Wife.
CP has been filed by wife there. Seeking 13-1.
Again, I was.
13-1 wife file करचंदी sure. Then C has to file 25 also or 24.
Yes,
and 24 has been allowed.
Yes, my lord.
So now then you actually you should not pursue this here. Usually what is happening, whenever the husband is getting order, at least till now, whatever matters I have taken up, all matters are challenged by husband. This is the first matter where the wife herself is challenging a 24 order. Very limited scope. 24, if you read the provision, the scope is very limited. Court is examining prima facie. The language used is it appears to the court that. So this is not a final order. After examination of the detailed examination of this, if you apply monthly, Rajneesh versus Neha, the court will enter into an inquiry of the rights and assets and liability of the husband and the wife. That is no scope for 24. So by keeping this, the other matter pending in the trial court gets impacted. It's just possible that since there is a lot of pressure on that court in Bhubaneswar, two courts but still a lot of pressure, the matter gets adjourned. So you should not pursue this matter this way. And if you are dissatisfied with the quantum, then 25, this court has no jurisdiction. I cannot enhance.
Right.
Yes.
And on 19/8/2025, that CP which they have preferred before the learned family judge has already been dismissed on default mind.
Then what is the scope of 24 also? 24, then there is no 24.
For a moment, my lord.
Please.
With respect to my senior counsel, my
Restored again.
I
have restored he is upon returned or file.
With respect, my lord.
No, you should not be impatient at this amount of spending this time.
My apologies.
You are sufficient. No. Why should be apologetic? You are doing your job. You are right. He's right in saying that if you once said, if it is on record that it has been dismissed, then you should have brought to the notice that by filing rejoinder.
My lord, today the date is fixed before the trial court, my lord. Restoration already filed, notice issued, notice held to be sufficient, my lord. Today date is fixed before the trial court, my lord. For which I am praying for one adjournment, my lord.
Correct.
I will file the...
You take adjournment. In fact, at least the discussion has been fruitful. Now you understand. This petition filed and kept pending here has served no purpose. Already once the matter has been dismissed there. After it is dismissed, there can't be any 24.
Yes.
24 is subject only, subject to pendency of a CP. 13 could be 9 also. Could be 9 also, 13 or 9. That is, if that is not there, then how can this court adjudicate whether 24, what amount is to be paid from the date of filing or date of pronouncement of order?
My lord, I humbly pray.
Going 25, now again 25, obviously if it is pending.
Lord, I humbly pray.
Yes, I am granting adjournment, but please be serious considering this aspect also.
Lord,
yes.
My lord, can I put a question to myself? When this matter has come up today and the matter has already been dismissed on default, my lord, can it not dismiss?
There are so many reasons for adjournment. Adjournment is a strategy.
Bow down, my lord.
Adjournment is a clear-cut strategy in most of the cases.
But when that
you were present when the other matter was argued, Mr. Satyavrata Mahanti.
Yes, my
14 lakhs has been deposited.
Yes.
And the matter is getting adjourned. Here after the amount is deposited, in appeal also, at least I have seen that, it is getting adjourned. So it is both ways. It is a matter of strategy, less dispatch is better.
My lord, this may be observed as...
No, I'll record. I'll record because we are spending time over this.
Yes.
This submitted by Mr. Hard Learned Counsel for the petitioner and the opposite party. The petitioner wife is before this court.
Yes.
Partly challenging the order dated 6. You both of you, can you take your seat? No need to stand up. If required, I will ask you. 6/7/2023 passed by the Learned Judge, Family Court, Bhubaneswar, in IA number 6 of 2021, arising out of CP number 55 of 2021. The said CP was filed by the petitioner wife seeking decree of divorce under section 13 1 of the Hindu Marriage Act. Please mark my dictation note.
13 only.
Only 13. Section 13 of the Hindu Marriage Act. During pendency of the petition, the IA was filed seeking maintenance under section 24 of the Hindu Marriage Act. And the order was passed, which is challenged herein. It is submitted by the Learned Counsel for the petitioner that in all fairness, the court would have granted. The court should have granted the maintenance with effect from the filing of the petition and not from the date of passing of the order, as has been done in this case. It is further submitted, it is further submitted that the petitioner also wants enhancement of the maintenance stop. In response, the Learned Counsel, Mrs. Patnaik submits that during pendency of this writ petition, the CP was dismissed for non-prosecution by order dated. Upon a counter file
By 1908.
The reference to the counter to submit that it was dismissed by order dated 19/8,
2025.
2025 for non-prosecution. Therefore, the cause of action seeking maintenance under section 24 of the Hindu Marriage Act would not survive. The Learned Counsel for the opposite party also argues that in view of the doctrine of merger, the order passed under section 24 of the Hindu Marriage Act also merges with the final order dismissing the CP number 55 of 2021 on 19/8/2025. It is submitted by the Learned Counsel for the in response, it is submitted by the Learned Counsel for the petitioner that thereafter the CP has been restored as the petitioner has again filed an application for restoration which has been allowed.
No, madam, for a moment.
That
It was
has
not
been
allowed.
posted today.
Yes, madam.
But
Oh, restoration file କରିଛନ୍ତି
File ହେଇଛି।
ତାହେଲେ ଆପଣ ଏମିତି କାହିଁ କହିଲେ?
No, my letter.
ଠିକ ଅଛି କଣ ଲେଖିଲେ ତା ମାନେ ପିଟିସନ ର କିଛି ନାହିଁ ବର୍ତ୍ତମାନ ଏଠି ଚାଲିଲା ଦି ଜାଗାରେ
when I filed this, they thereafter filed the restoration.
ତାଙ୍କୁ ଡିଷ୍ଟର୍ବ କରନ୍ତୁନି, he is in full grip of the facts. ଆପଣ he will be unnecessarily distracted and anxious. ସେ ତ ବଢିଆ କରୁଛନ୍ତି ଆଉ କଣ ସରି ନାଇଁ ଆରେ ଆପଣ ବି ସରି କଲେନି, ସେ ବି ସରି, ମୁଁ ବି ସରି। କଣ ଲେଖିଲେ ଆପଣ ସରି ଲେଖନ୍ତୁନି, ଟାଇପ କରିବେ ନା କଣ ଲେଖିଲେ? ନା the application has been filed
CMA by 98 by purpose.
CMA
By 98 by
भूल भाल ହେଇଯାଉଛି ସେ ଟାଇପିଂ ରେ। application has been filed for recall of the order of dismissal dated 19/8/2025 which is posted for consideration today. That is ଆଜି କେତେ 12 ତାରିଖ, that is 12/1/2026 before the learned family court Bhubaneswar. Now तीनटा कोर्ट भुवनेश्वर हेले भी हबन। There is a court 2, court 3, court 4. I don't know. I mean, how we will manage this? कौन लिखी? For consideration. It is submitted by Mrs. Patnaik for the opposite party that such fact has not been brought to the notice of this court by filing an agenda. However, at the request of the Learned Counsel for the petitioner, the matter is adjourned to be listed in the week commencing केबे चाहुचंदी?
February 1st week.
ठीक अछि। In the week commencing केबे 2/2/2026. But you should not press it here because this is completely ambivalent. Because 24 you are pressing on merit, you are challenging order which favors you, and 25 no jurisdiction. I cannot enhance 25. Must appreciate. 24 enhancement you can file there also. Absolutely. 24 the complete lack of jurisdiction. Because pendent maintenance, how the appellate court will deal. Appellate court means division bench in High Court. How it will deal with a pendent maintenance application. Yes.
25.
You are Mr. KK Sethi.
No,
or A rank.
Abhishek Pradhan.
पावर नहीं ଆଉ ଏଟା ତ ଆପଣ ଚେମ୍ବର ମ୍ୟାଟ ଆପଣ ଓକିଲାତ ନା ଫାଇଲ କରୁନାହାନ୍ତି
Yes, sir.
ଅଭିଷେକ ପ୍ରଧାନ
Yes.
So Abhishek Pradhan for the petitioner. So Anshuman Sethi AC for whenever you are appearing in a chamber matter, you file your Okalatnama because that adds creates confusion. Who is appearing for whom? All these things have to be recorded. For OP1, why state is a party?
Lordship,
125.
164 report has been asked for, so.
Okay.
Legible copy of 160.
Co-order impugned order? Upon last order कौन थिला?
Order dated 25/8/2025.
25/8.
8/2025.
One 164 କାହିଁକି ମଗା ହଉଛି ଏଥିରେ?
Lordship, we are seeking for transfer of ST case number 46 of 24 to Paleswar Court to Bhadrak Court because the jurisdiction, the occurrence took place at the jurisdiction of Bhadrak. Also.
ସେ ଆସିଲା ଆପଣଙ୍କର ଇଏ
Lordship.
ତାହେଲେ ଆପଣ what you do, you go through that, you make your submissions.
Lordship.
Okay. Because what has been recorded is that the learned AG could not get the records proper records, so he sought for time. But in the meanwhile, have you received it?
We have received.
Okay. Appearance देखिए. The submit the learned counsel for the petitioner refers to the order dated 25/8/2025. Wherein the matter was 25 stop put in by the said order, the learned counsel for the state was directed to obtain instruction. Right is submitted by the learned counsel AAC that he has received the copies or legible copies of the 164 statements. He will examine the same and the matter may be adjourned. Accordingly, the matter shall be listed in the week commencing 2/2/2026. Interim order passed earlier shall continue till the next date. ଆପଣଙ୍କର jurisdiction problem କେମିତି ହେଲା local area ରେ? ହବା କଥା ନୁହଁ
ହବା କଥା ନୁହଁ ବଟ୍ ସିମୁଳିଆରେ ଯେହେତୁ ସେ କରିଦେଇଛନ୍ତି ସେ
FIR କୋଉଠି ଲଜ୍ କଲେ?
FIR ସିମୁଳିଆ police station ରେ
that is in Baleshwar.
That is in Baleshwar, but jurisdiction comes in Bhadrak.
Let us see. Yes.
26.
Lord, on behalf of SK, the opposite party has not filed the objection.
Mr. Sanjit Misra, my lord.
I have to get some relevant information from the opposite party.
ଆପଣଙ୍କ ନାଁ ଆଜ୍ଞା?
Abani Ranjan Das from Power 9 on behalf of SK.
Mr. Abani Ranjan Das on behalf of AR Das, Abani Ranjan Das on behalf of SK Bhanjadev for the petitioner, Mr. Sanjit Misra. You are Mr. Misra?
For the respondent.
For the opposite party. What is the nomenclature? They are writing petitioner opposite party or appellant respondent? कौन लिखुଛନ୍ତି? 24
Opposite party.
petitioner opposite party because it is a petition most likely. A petitioner opposite party. The learned counsel for the petitioner submits that objection on behalf of the opposite party has not been filed as as directed by order dated, as observed by order dated 11/11/2025. Para. The learned counsel for the opposite party submits that he has to receive instructions from the opposite party and the matter may be adjourned. Accordingly, the matter shall be listed in the week commencing 27/1/2026. Interim order passed earlier shall continue till the next date of hearing.
Blessed. 27.
Miss Mahapatra. Your name, madam?
S. Das. Sangeeta Das.
Good. Power 9. Miss S. Das, on behalf of A.K. Behra for the petitioner. Mr. Prabhat Ranjan Sutar for the opposite party. Mr. Deo.
No, I am
Sutar. Sorry, Mr. P.R. Sutar for the opposite party. Yes.
My lord, the wife petitioner seeks transfer of divorce proceeding from Learned Court Family Judge Kendrapada to Jajpur on the ground that the three cases at the instance of wife are pending at Jajpur. Wife is a staff nurse at Sambalpur and husband is residing at Cuttack and serve as an accountant in National Law University. Husband has already appeared at Jajpur in 3 cases of the wife, but filed divorce case at Kendrapada Court. On the part of the wife, it is difficult to travel from Sambalpur to Kendrapada.
My lord, all the 3 cases filed at Jajpur by the petitioner has already been dismissed.
You want to copy? तांका पर instruction टा नहीं. File करूँ तो copy टे भी दियो तो. You favor. It is hard on counsel for the petitioner. He reiterates the prayer of the petitioner for seeking transfer of the cases pending at Kendrapada to Jajpur. In the case or cases, plural or singular? Kitna case pending achi?
One DV cases pending at Jajpur, 1 criminal proceeding and 1 CP.
Three cases pending.
All the 3 cases are dismissed by the
Jajpur to. Like, उल्टा है गला. आपनो कोटी ट्रांसपोर्ट चाहूँ
Kendrapada to Jajpur.
केंद्रापड़ा कितना केस?
Kendrapada रे husband file करछन तो गोटे केस. Jajpur रे wife file करछन 3टा केस.
अच्छा. और लिखिए transfer of case filed by the husband, opposite party at Kendrapada to Jajpur. The learned counsel for the opposite party produced this photocopy of the order. Dated 14/5/2024, passed in CP number 249 of 2024 by learned Judge Family Court Jajpur. Order dated 14/5/2025, passed by the learned Judge Family Court in CRP case number 186 of 2024. And order dated 14/11/2025, passed by the learned Judge, learned
Judicial
Magistrate CJ JD Com JMFC Boripal, Jajpur, dismissing the DV case number 157 of 2024 by 14/11/2025. The photocopies of the order, memo diuntu. Photocopies of the order filed along with memo is taken on record. It memo shall logate diuntu. କପି ନାହିଁ ଆଉ ଆପଣଙ୍କ ପାଇଁ ଏକ୍ସଟ୍ରା କପି ନାହିଁ ନା କଣ?
ଗୋଟେ କପି ଦେଇଦେଇଛି ଏକ୍ସଟ୍ରା କପି ଥିଲା।
ତାହେଲେ ଆପଣ ଆଉ ଗୋଟେ କରିକି ଦେଇଦେବେ,
ମାଇଲର
ସୁତରାଙ୍କୁ ଦେଇଦେବେ। ଆପଣଙ୍କ ପାଖରେ ନାହିଁ ସେ ଦେଇଦେବେ ଆପଣଙ୍କୁ।
ମାଇଲର
ଠିକ ଅଛି, ଫାଇଲ କରନ୍ତୁ, ସେ ଦେବେ। ଆପଣ ଷ୍ଟାମ୍ପ କଲା ପୂର୍ବରୁ ଜେରକ୍ସ କରି ଦେଇଦେବେ। ଅନେକ record. Yes, madam, nothing survives. In view of the above developments, nothing survives in the petition. The petition is disposed of accordingly. Copy of this order shall be forwarded to see the तीन जनों का नाम लिख लेने की to so and so, so and so, so and so,
and minor
by the registry to be kept on record of the respective cases.
minor to the Kendrapada, that case has been stayed by this honorable court. Divorce case filed by the
The
opposition.
merge करिएगा. Doctrine of merger होगा नहीं.
Minor.
In view of the disposal of the petition, the interim order passed earlier stand vacated.
Minor.
Yes. ଆପଣ ବୁଝିଲେ ନା ନାହିଁ? Both of you have you followed?
My lord.
Then no difficulty to ask me that also. I mean,
I have no instruction.
there is no. You shouldn't hesitate to know certain things.
Yes.
Since you are seeking some transfer of cases on that ground, pendency, the court has stayed the matter. Those cases are no more pending.
Yes.
And he produces the photocopy of the certified copy.
Yes, Lord. So I have no instruction regarding this same.
Could be. Maybe that is the reason that she is not responding. ଆପଣଙ୍କୁ ସେ ଆସୁନାହାନ୍ତି ସେଥିପାଇଁ ବି ହେଇପାରେ.
Yes, Lord.
Yes. Yes, next.
28. My lord, I am for the corporation, my lord.
Yes, please.
Your Lordship, I am for the petitioner. In the previous occasion, we have filed the VNAMA and in the file, the counter is missing. So we have urged to the opposite party to for the copy service of the counter. So yet you have not received.
ସେଟା ଅପୋଜିଟ୍ ପାର୍ଟି କୋଠୁ ନେବେ ନହେଲେ କୋର୍ଟରୁ ନେବାକୁ ପଡିବ ଆପଣ ତାଙ୍କୁ ସେ କହୁଛନ୍ତି ତାର ଟ୍ରାନ୍ସଫର୍ଡ ହେଲା ପରେ ବ୍ରିଫ୍ ମିଷ୍ଟର ଶତପଥୀ has been after he has become the member judicial so he requests for copy. Your name sir?
Devashish Sahu.
Mr. Devashish Sahu along with Mr. Pragyananda Patnaik.
Yes.
Mr. Devashish Sahu for the petitioner, Mr. Satyanarayan Mahapatra for the OP number 3 and 4.
Again.
My lord, I am for the 5 and 6.
Yes, yes. Mr. Ajit Kumar Mahapatra for the OP number 5 and 6. Panel counsel के नांती ना वीडियो रचंती. OP1, anyone present from DSGI's office? नांती ना? OP1 none. Hybrid mode लिखती है. ESA पे क्या पेयर करछंती 3 and 4 पे आपण
ମୁଁ ESA पे
अच्छा then 1 पे के नांती मिस्टर अंशुमान सेठी ASC for OP2 मिस्टर सत्यनारायण महापात्र for OP number 3 and 4 5 and 6 तो लिखले ना it is submitted by Mr. Sahoo learned counsel appearing for the petitioner that since it is a transport brief he has not been able to locate the counter filed by the opposite parties को opposite party का counter पाउना कोडे भी नहीं किसी भी नहीं अपन
नहीं से कॉपीटा काउंटर कॉपीटा नहीं opposite party.
She shall have the liberty to obtain the copies from the registry of the court and or the copy may be obtained from the by requesting the learned counsel for the opposite parties. Yes, the matter is adjourned to complete the pleadings by the next date. List in the week commencing 2/2/2026. Yes, please. Next.
29.
This is Aishwarya Das for the petitioner. Mr. A.K. Vishwal for the opposite party. This R.R. Pradhan. Yes. R.R. Pradhan for the opposite party along with Mr. Vishwal. Yes, Ms. Das, Mrs. Das.
The order in past in section 24 application has been challenged by husband, my lord. That is 3,000 per month,
Yes.
along with 10,000 litigation expenses. My lord, what I
10,000 one time. 10,000 is one time.
One time.
Yes.
my lord, what
Your
instruction?
senior is charging much high. We can't engage your senior
No, my
with 10,000. See, rather, see.
lord, what I got instruction is that the matter can be settled between the parties. If one mediation maybe it be,
No, here mediation scope is, there is no scope for mediation.
my lord, not here. Before
There, you make an effort. You see, the problem is whenever you are challenging interim orders, in a pending family court, this kind of 13 is filed by whom? Wife or husband?
husband's file.
Husband has filed 13. So 24 order is passed.
My-
How can he resist 24 order?
Cannot.
And if like in one matter, the matter has progressed substantially, then no point in keeping this matter pending. Because in rarest of rare case, the court interference in 24 orders where it is interim order only. And quantum is not exorbitantly high.
Yes. My lord,
10,000
my
litigation
legal
exception.
objection is she
exception-
herself left the house as and living a adulterous life.
That is the problem. That is the problem, madam.
that
Once you say that, this court has to raise its hand.
I guess it evidence nahi prove.
Yesterday, if you read the Supreme Court judgment in one matter, where the Allahabad High Court has directed for evidence, examination of age of the victim or the perpetrator accused, Supreme Court has said at this stage you cannot do. It was a bail petition because that will touch upon the merits of the case. Cruelty is a matter of proof, and in hardly any very few matters cruelty is adopted because it is very difficult to prove. Desertion is fine, and voluntary desertion has to be proved then, because the wife touches the husband touches the wife,
And
then what would happen?
Cheated by her.
Then takes the plea that the wife has deserted him.
She herself left the house.
So voluntary desertion is a difficult. Again, it has a matter of proof.
The case has been initiated, my lord.
So that can be grabbed in 25, but not in 24. Because the language usage finds that, or some that word and again today referring. Court is of the opinion, I think. So very difficult, madam. It appeals to the court. 24 order to pass an order in 24, it has to appeal to the court that it is liable to be paid. Nothing beyond that. There can't be any kind of a heavy burden of proof on proving it. And 3,000 cannot be said in any standard to be exorbitant.
But up to pray, my lord.
So you see, simply I'm adjourning it, recording that there is a possibility of settlement.
Well,
Both of you obtain instruction from if you are conducting counsel in the lower court. So far, so good.
lower court is best, my lord, because
Correct. But are you conducting there?
no.
You have to mediate between the lawyers actually. For various reasons, the matter is getting lingered.
As per the briefing of the instruction, my lord, I'm submitting that.
Correct. They have
There
to.
is chance if court may.
So, pendency is pendence of this case is not preventing them for mediation at least. Rather, it should be withdrawn to prosecute the matter there.
One thing.
And she has not filed an enhancement application.
No,
Then
He has not paid also, single 5 years and paid also.
that's the usual story.
I'll not press the application, this court may direct.
I am not saying you obtain instruction, but as far as expediting the matter is concerned,
That
you have to tell the court that what is the stage, because it's a 24 application.
the stage is husband has filed his evidence and respondent side evidence is up to file, yet not with file, my lord. If my lord may.
I can object that none of you will obstruct the proceeding, cooperate in the proceeding, that order I will pass.
My lord, that.
But without directing the court that you finish, because that will be discriminating the other litigants.
My lord, that may be. That will not reduce it, ma'am.
Appearance tax bill. এটা কোন ম্যাটারটা কত নম্বর এটা 29 Mrs. A Das for the petitioner, Ms. R.R. Pradhan along with Mr. Anjan Kumar Bishwal for the respondent. the petitioner husband is before this court challenging the order dated 5/8/2024 passed by the Learned Judge Family Court Balasore in IA number 7 of 2023 arising out of CP number 670 of 2022. Stopped by the said order, the Learned Judge Family Court has allowed the application under Section 24 of Hindu Marriage Act filed by the respondent petitioner wife granting monthly maintenance, pendental light maintenance of 3,000 and litigation cost lump sum of rupees 10,000. Stop. In response, the Learned Counsel for the opposite party submits that the said amount of 3,000 has not been paid to the respondent opposite party in the CP. But on a query from the court, the Learned Counsel for the petitioner submits that the CP. In the CP, the evidence of the petitioner husband has been recorded and the evidence of the opposite party is to be adduced. In all fairness, the Learned Counsel agree that the matter can be expedited if the parties cooperate in the proceeding. Accordingly, without further keeping the matter pending, as it would no purpose in the interest of justice. It is directed that the parties shall cooperate in completion of the proceeding as expeditiously as possible. They shall not seek any unnecessary adjournments. The Learned Judge Family Court, Balasore, shall make an endeavor for expeditious disposal of the matter, keeping in view the pendency of matter in his court, in the said court. The petition is disposed of accordingly.
Hotel line petition execution petition would file that may be considered.
No, there is no bar. There is no bar. No, execution. I'm not. Rather, it is because she should make that prayer. That since her challenge has not been considered. So, but I cannot no, because it is his challenge. I cannot say that his challenge is without any merit. Because that becomes difficult for a lawyer to concede to that extent. I have to maintain a balance.
Yes, only that much we observed. If any
So
petition
execution,
if any petition will be filed, that will be considered on it.
You start paying something.
And only observation, if any petition will be filed by the opposite party, that may be considered as per law.
Because you see, it is his petition challenging the hour.
Yes.
So when I am not entertaining, I should not pass anything further.
What time may be, please, if possible?
No, time I am not fixing. Time. Because that becomes a difficult situation. I do not know how many cases are there. And other petitioners who are not before High Court, how they will be prejudiced? Yes. Yes, Mr. Behra? So that disposal. So nothing survives, that much I have said.
On the phone they have already a certified copy and July masal. Thereafter she has filed for restoration.
Correct. And restoration is yet to be taken up.
Yet to be taken up. Number one.
So the problem is that is the argument against you. Just now one matter was there. I was dictating the order that has been restored. They said no, it has yet to be taken up. So after it is taken up, you may file that petition because it will not be res judicata.
That's right.
Yes. So keeping this matter pending leads to nowhere. Because the logic of keeping the matter pending is that the petitions in Jajpur are pending. when the petitions in Jashpur have been disposed of, there can't be any whatever semblance of reason to keep the matter transfer petition pending.
That is the one of the ground. Number two, ladies at Hon'Ble.
The problem is that ladies at Sambalpur, she can seek it to transfer to Sambalpur also. That is another thing. She is working at, she mentioned that. She
Because
mentioned,
of the fact that husband is staying at Kotak and he is attending at Jashpur, it will be convenient for both of us. That is why the petitioner sought for transfer from Kendrapada to Jashpur. That is the consideration.
that cannot be. Sambalpur और केंद्रापड़ा मझे जाजपुर केमती होगा आगे आपण जड़े लोकल जज को एटा केमती बुझौचंती so only ground for interference by the coordinate bench is that pending petitions are no more there. So let us see what is happening in that another matter only that just before that in Bhubaneswar, same thing. After filing a petition, long since it is dismissed. 25 had to dismiss it. In January, the court, how the court can keep it pending? For what purpose? So there are to be more tough. More tough. And the court say that it will be restored. It should not be also. Either way, this is ambivalent state. Let us see what is happening. And suppose in between Kendrapada and Sambalpur, how Jashpur comes. Jashpur never comes.
Middle point ହେଲେ ବି ହେଇତା
middle point ବାହାର କରନ୍ତୁ ସେଟା ଅଲଗା କଥା
ସେଟା ହେଲେ ଟିକେ ନା
so ସେଟା ଆପଣ କୋଉଠି କେନ୍ଦୁଝର ହେଇପାରେ କି ଝାରସୁଗୁଡା ହେଇପାରେ କୋଉଠି ଆପଣ ବାହାର କରନ୍ତୁ ଅନୁଗୁଳ ହେଇପାରେ
ସେଟା ନହେଲେ
so that is a different thing and separate adjudication. In Odisha, it is not that difficult.
That is not.
The lawyer will take care of the situation.
Your lordship knows a staff nurse solving
could be
medical.
So maybe she will seek it the direction for, we do not know. We cannot say. Both of, I mean, you and the court, can we say that she will not seek the transfer to Sambalpur? She may seek it to Sambalpur.
That can be.
So this order is perfect. She has done a good job.
Not so.
I mean,
he and she are in good job.
But the problem is that by taking into account what would be her petition in future, today the order cannot be passed.
No,
obviously, this ground, what has been filed in this particular petition is that pendency of case at Jashpur. That is the ground.
That is the one of the ground. Because it is 250 kilometers ହେଇଯାଉଛି ସମ୍ବଲପୁର
Whatever, you file that, but you don't take the ground of pendency at Jashpur.
ସେଟା
Obviously.
ଖାଲି liberty ମାନେ subsequent development.
Sir, when there is no bar, when there is no bar, how can I prevent that or I can allow that? There is no bar. It cannot be res judicata. ତାଙ୍କର transfer ହେଇଗଲା ସମ୍ବଲପୁର ଧରନ୍ତୁ ହେଇଗଲା ମାଲକାନଗିରି. It will be a bar for consideration. So you never know. Again, sir, after it is restored, then they will file a transfer. Who knows? Because this order is only limited to the situation where the three has been disposed of. So even if you say, so please think it and then you argue. There is nothing, at least no negative as far as the wife is concerned. She can anytime file. She may seek it to Sambalpur or after restoration she may file any other petition.
In the meanwhile, the proceeding re khali liberty jo video conference re bhi se appear kari.
Their petition has to be filed and rejected. Please appreciate that. Video conferencing always encouraged. Remote location, taking of evidence. Everything is encouraged. Yes.
Question 30.
Mr. S.K. Mehrula for the
31.
30. Mr. Mehrula for the petitioner. Mr. Das, are you present? Opposite party blank. The learned counsel for the petitioner files memo of date stating the following. The said memo encloses the judgment dated 24/12/2025 passed by the learned judge Family Court Dhenkanal, dated 24/12/25 in CP number 178 of 2025. Stop. In the said CP, the following order has been passed. Order Tachi, page 6. The application under section 13-B Puneki run accordingly Parjanta. The memo is taken on record. The petition stands disposed of. Yes, next. 31 Mr. Upendra Kumar Samar for the petitioner. Tripathi, one is there in VC. So Patnaik, you are there.
Well,
Mr. A. Patnaik for the opposite party. Yes.
Here is a wife is the petitioner. She filed an application under section 125, now 144 of the BNSS. The husband, though appeared, did not file his written statement. Though contested the petition, but did not cross-examine the wife, and even did not file any affidavit pertaining to assets and liabilities. Therefore, the trial court, the judge family court, while the husband is the manager of post payment bank and receiving a salary of rupees 1,20,000 and agricultural income of 30,000, total aggregate is 1,50,000, awarded an amount of rupees 7,000 per month.
Any other proceeding, connected proceeding?
No other proceeding.
Only 125?
Only 125.
The lawyers are inefficient there or what? Any matrimonial matter, there has to be 5-6 proceedings.
To my knowledge, in fact, it is from Borgad.
No, if there is it that they are in good terms, then it's the most welcome change. Suppose they are having a very good cordial relationship.
Only dowry of demand for dowry, nothing else.
My lord, the matter may be sent to the mediation center.
Sir, what is the scope of mediation in 125? Sir, there is no right side bench. I have become single now. So what kind of mediation in case of a 125 CRPC?
Pay slip ta ଟିକେ ଦେବେ କି ତାଙ୍କର ଏଇ ଏବେ current
ଆପଣ instruction ନିଅନ୍ତୁ. Mr. Patnaik, it is not a, I said in a lighter vein in there, but it is a serious, it has a pertinent and serious thing. If they are having good relationship and staying together, there is no other case. Or there may be 13B also. The last matter 30, what was there, they have obtained 13B in the meanwhile. Sir, for what? Mediation for what? I will say, I am asking you, I am seeking your assistance. You have to educate me.
Reunion, my lord.
Reunion in 125 CRPC, how can I presume that they are estranged? You see, suppose the husband stays in Dubai, doesn't give any amount. They are good relationship. So what the wife will do? She will file a 144 now. 144.
144.
144 Nagarika Surakya Sanhita. Then earlier he used to file 125. How the court will presume that they are separated? Please appreciate this as a serious, angularity also. Simply, any order passed by the court should be has some.
My lord, in the self-same para, my lord, para 9, it has been reflected that the declaration submitted by her in view of the direction of the Honorable Apex Court passed in the case of Rajinishi versus Nea, with regard to income of the opposite party, is also found to be ambiguous. And she, at one hand, declared that the opposite party is doing government service, is earning 120,000 per month. On the other hand, she, though the contents of the said declaration further submitted that the opposite party has passed 8th standard. See 8th standard of pass kari manager ke india
ko jaga re lekha hai cheta uti bahar kari dekhe dele mat mu pai
judgment re
ne judgment re je pleading ro ko part re lekha hai je 8 pass ame lekhichu bol
same assistant finally lone trial court ente avastha hala tankar se au ko pleading ko adhani misei debeni
ko jaga re lekha hai je dekho na am affidavit re
so patna Mr. Samal saying that 8th class kotha ko lekha hai ni boli
in judgment re lekha
so that's a serious error pointed by Mr. Samal also. You are also pointing a serious error, he is also pointing a serious error. Judgment କୋଉଠୁ ଆଣିଲେ ସେ ସେଟା ପଚାରୁଛନ୍ତି।
ଲେଖା ହେଇଛି
ଆରେ judgment ରେ ଆପଣ ପିଟିସନ କରିବେ ନା ସେ କହୁଛନ୍ତି ପିଟିସନ ଆପଣ କହୁଛନ୍ତି ଜଜମେଣ୍ଟ what the appellate court will do
instruction ନେବି
ଆପଣ instruction ନିଅନ୍ତୁ no difficulty if you are saying that they have in the meantime they have separated they have decided to part peacefully 125 there is no scope for mediation
ଗୋଟେ କଣ୍ଟିନ୍ୟୁଏନ୍ସ ଅଫ ଦି ଅରିଜିନାଲ ପ୍ରୋସିଡିଂ ତାଙ୍କୁ ଖାଲି ଗୋଟେ ପେ ସ୍ଲିପ୍ ଟା ଦେବା ପାଇଁ କରେଣ୍ଟ ପେ ସ୍ଲିପ୍ ଦେବା ପାଇଁ ଗୋଟେ ଡାଇରେକ୍ସନ
ସେଟା ଆପଣଙ୍କର 8 କ୍ଲାସ ବୋଲି କହୁଛନ୍ତି ଆଉ ମାନେ ଆପଣ କ୍ଲାଏଣ୍ଟ ହଉଛି 8 କ୍ଲାସ ତ କଣ ଦେବେ
ସେ ମନା କରିଦିଅନ୍ତୁ ନହେଲେ ଯେ ଆମେ ପୋଷ୍ଟ ଅଫିସରେ ଚାକିରି କରୁନୁ ମୁଁ ତାଙ୍କ ଆପଏଣ୍ଟମେଣ୍ଟ ଲେଟର ଜେରକ୍ସ କପି ଆଣିକି ଦେବି ଆପଣ ମନା କରନ୍ତୁ ଯେ ଆମେ ପୋଷ୍ଟ ଅଫିସରେ ମ୍ୟାନେଜର ନାହୁଁ
ଆପଣ ବହୁତ କେସ୍ ମିଷ୍ଟର ପଟ୍ଟନାୟକ ଆଇ ହାଭ୍ ବିନ୍ ଟେଲିଂ ୟୁ ସିରିୟସଲି ଆପଣ କୋଉ କେସ୍ କୋଉଠି ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି ଆପଣ ଦେଖିକି କରନ୍ତୁ ଆପଣ 8 କ୍ଲାସ ଏଇଥିରେ କୋଉଠୁ ଆଣିଲେ ଜଜମେଣ୍ଟ ଲେଖା ହେଇଛି 8 କ୍ଲାସ
ଲେଖା ହେଇଛି ଆଜ୍ଞା ସେ କାଇଣ୍ଡଲି ସି ପାରା 20
ଅପ୍ଟେନ୍ ଇନଷ୍ଟ୍ରକ୍ସନ
page 22 last line ଲେଖେ
लिखिले appearance had learned counsel for the petitioner it is submitted that though the learned the learned judge family court has noted the occupation of the petitioner learned judge family court Bargad has noted the occupation of the petitioner while deciding the amount payable as maintenance as sought for under section 125 CRPC public 144 BNS. The amount granted is very less, that is at rupees 7,000 per month. The learned counsel refers to the cost title of the judgment, where the respondent husband in the marriage is mentioned to be working as branch manager, Indian Post Payment Bank, Sonpur. Sonpur at RO is Udaipur. Sonpur, Udaipur in the district of Anugul.
Right.
In response to the learned counsel, Mr. Pot opposite party husband submits that the judgment records the fact that the opposite party shall be employed as branch manager of Indian Post Payment Bank. Para. The learned counsel for the petitioner submits that the submission of the learned counsel for the opposite party husband, referring to the judgment passed by the learned judge family court Bargad, is not borne out of the records. The learned counsel for the opposite party seeks adjournment to obtain instruction. Accordingly, the matter shall be listed in the week commencing 2/2/2026. In the meanwhile, it is expected that the learned counsel for the parties shall make an endeavor for arriving at an amicable settlement between the parties acceptable to both. But you have to motivate the lawyers.
ଖାଲି ଗୋଟେ ସେଣ୍ଟେନ୍ସ ଲେଖିଲେ ସେଟଲମେଣ୍ଟ ହେଇଯିବ ତାଙ୍କୁ ଇମ୍ପ୍ରେସନ ଦେଇଛନ୍ତି ଯେ 5-7 ହଜାର ଭିତରେ ହେଇଯିବ ସେ ଯଦି ଜାଣିବେ ଯେ ତାଙ୍କ ମାନେ ଆର୍ନିଂଟା କେତେ କୋର୍ଟରେ ଫାଇଲ କରିବାକୁ ପଡିବ ସେ ସାଙ୍ଗେ ସାଙ୍ଗେ ସେଟଲ କରିଦେବେ ସେ ଯଦି ଜାଣିବେ ଯେ କୋର୍ଟଟା ବି
ତାଙ୍କୁ ଏମ୍ବାରେସ୍ କରନ୍ତୁ କେବଳ 8th standard ତାଙ୍କୁ କହିଛନ୍ତି ମୁଁ 8ମ ଶ୍ରେଣୀ ପଢିଛି ତ ମିଷ୍ଟର ପଟ୍ଟନାୟକ ପଚାରେ ଯେ 8th class question ସେ କହିପାରିଲେନି. Yes, next.
32, my lord, I am for the petitioner, my lord, and I am maybe permitted to argue on behalf of Mrs. Pati.
I'm sorry, I just forgot your name.
Mrs. S. Das.
Mrs. S. Das on behalf of Mrs. U. Pati for the petitioner. Mr. Amit Prasad goes for the opposite party.
My lord, this petition is filed to seeking...
Yes, yes.
My lord, this
No,
petition is...
basically, since we'll be running short of time, so this is challenge to 24.
under section 24 to transport the CP case number 3523 from family court Balashar to Bhadrak, my lord. Now the petitioner is staying at Bhadrak. Now both the children are staying with me. To be honest, I'm saying that I am working as a private teacher in a private school in inter area. I'm getting 2,000 rupees per. Your lordship must consider how the educational cost, and it is for difficult for me to transfer to travel since 53 kilometers to attend the court, my lord. And now I underwent surgery, my lord. I have even annexed the medical certificate in my rejoinder affidavit. Now it is really difficult to move from Bhadrak to Baleshwar, my lord.
Not that difficult, as you say, but anyway, since you are arguing, it has to be said that because moving from Bhadrak to Baleshwar is not that difficult as you are saying.
Since I am underwent a surgery, my lord.
Baleshwar has a medical college. Bhadrak doesn't have.
No, I underwent a surgery.
So for surgery, you see,
lordship said that my teen is
CP is not to be attended every day by the person. Unless you are summoned for, using evidence or recording your statement.
But your lordship.
My lord, let her complete. I'll ask.
No, so in the sense you object vehemently, but should we allow this to?
My lord, your lordship can allow, but subject to, she comes with a clean hand before your lordship.
I have already come with
madam, ଆପଣ ସାରି ସାରନ୍ତୁ ମୁଁ କହିବି ନହେଲେ ମୁଁ କହିବି.
Yes. No, I'm just interacting with you.
I just want to say one line.
To arrive at something.
Well, now it is.
First of all, आपनकर जो theory होती है भद्रकରୁ ବାଲେଶ୍ୱର ଯିବା ବହୁତ କଷ୍ଟ is cannot be because it is so well connected place.
It is around 53 to 50
No, it is so well connected. ଆପଣ କୋଉଥିରେ ଯିବାକୁ ଚାହିଁବେ ସେଟା ହେଲା କଥା.
One more thing, my lord. But one more thing. My lord, one more thing, my lord. How that unsafe to leave a daughter, to leave a teenage daughter, my lord, and there is no not a apart from me, there is not.
That Bhadrak will not be held at your home also. That is
that is around 20 from my house.
In this kind of situation, your parents have to support you.
My lord,
your parents have to support you. Because if you take a plea of the attending your minor child,
yes, sir.
It's a correct plea. But can it be ground to transferring of the case?
Well, since
because then the argument would be that court has to come to your residence to hold a court.
No, well, I'm not.
Because how do you know that by appearing at Bhadrak, your matter will be taken up out of turn?
No, my lord, but
you have to wait in the court. Suppose
it is
first question that court has to procure an attendance every day. Second, the court has to hold the court whenever you reach the court because your matter is to be prioritized. Then the logic completely fails. Whenever you are arguing a matter, just test the logic yourself so that you can convince the court. Because it is a very simple thing. Suppose you say that you do not want to remain absent from your house, then how you will appear at Bhadrak also? Bhadrak is a family court, as a district judge. He will not hold camp court at your place.
No, my lord, it's a 25 kilometers from my.
25 or 52 makes a difference if you are unable to reach the court or able to reach the court. You reach the court at Bhadrak at 4:30 or 10:30. You have to reach there by 11.
Right.
So your case, you have to wait till 5 or 4 or 2. Maybe that's for the lower court practice. How do you say that you are ensuring your presence in your house? Do you follow the question?
Yes, ma'am.
So how the court will say that you have, by transferring the petition from Baleshwar to Bhadrak, I have ensured your presence at Bhadrak at your home, attending the child. Unless I direct the Lord Judge Family Court that whenever the matter of so and so is taken up, you have to sit there at 11, take up that matter. Can this extravagant order be passed by this court? Cannot. Illegal order.
And one more thing, that the opposite party is very influential person. Since he is working as home.
Influential person, you have to file a petition in the court. The court has to assess it, not a high court. If he or she has influenced the court, you file that petition. By using influence, he will influence whom?
Influence during the period of travel.
Whom? Kahaku influence karibe?
No, see, mote.
Apon kahi influence tebe?
Man threatening korchen.
Whoever threatens in any proceeding, he is, chopping up the branch where he is sitting, because a simple application or FIR will be lost. How many FIRs you have lost? How many petitions you have filed? Don't go by concocted stories. That is not your job as a lawyer. Because these questions you have to ask, not the court to the lawyer. You have to ask this question to the client. Because the order that is to be passed by this court cannot be solely on the basis that since the wife has filed, it has to be transferred. It has to confer to certain logic, conform to logic. And also that confers logic in the order. Apolo jota kouchandi, that is completely illogical.
Can your lordship may consider my medical ground also? How is it?
Medical ground, unless you are required on those dates, tomorrow he will fall ill at Balasore. Can I guarantee, can this court stay that falling ill at Balasore is stayed until further orders? What would be my answer to him? How he will travel to Bhadrak? Illness of wife at Bhadrak has to be counterbalanced for the illness of husband at Balasore. And if she was ill, has she filed any petition there seeking time? It has been rejected.
No, never filed. She filed, does not file. Never filed any application for seeking.
So then madam, how do I sustain my order? Very difficult, madam. Much less he will go to Mr. Bose, will go to Supreme Court. He appears in Supreme Court. I am unable to sustain my order. No logic. Because you may say that the court is not relief oriented or what, but I have to test my here sitting here. I am not accountable, at least to law. At least I have to pass an order logically or in court. So the problem is these grounds are not good grounds for transferring petitions. And how much maintenance he is receiving?
Well, at 7,000 was ordered, but from 2025 April, they have opposite party stopped giving any maintenance ballot. He has already offered in his counter affidavit.
Maintenance by obtaining a stay or challenging that?
No, not challenge, but he has been paying.
How much total amount you have received?
7,000, that is total amount, my lord, since order was passed from the date of filing of application for maintenance, he has to give 7.
Total amount, madam. Simple answer.
Total amount.
500, 1000, 2 lakh.
No, 2 lakh to nahi ki no.
Kete tanga pauchundi?
7,000 pautili. Total amount mo seta kalpat from April 2025 he has not given a single pack. From it he has stopped giving.
For what?
For what reason he has to answer?
How he will answer? Are apno pautile pau nahanti seta se kemti kohibe? But apno hi kohibe what are the change circumstances? Because you see, upon the clear cut answer diyante je order hela comply kaleni, then obviously I will pounce upon him. Kai do nahanti. But upon to na epote kochundi na sepote kochundi.
Seta semane bond kar dichan tapare mu au kichi.
What is the reason? Anyway, he will answer because he has said that after any other submission. Because the problem is that once the notice is issued, the first thing the trial court lawyer is saying that you go and obtain a TRPC and stay here. That has frustrated the whole scheme of act. And Bhadrak and Balasore are the most nearby places. Baripada. If you go in that way, Bhadrak, Balasore, Baripada, even Jajpur will be little distance from, or the same distance from, because Jajpur court is at Jajpur town. Almost same distance. So if this way it is analyzed, then it becomes very difficult. Yes, Mr. Bose. Anything else, madam? Mrs. Das.
That's all.
Ailment? Leaving the child at Bhadrak alone? Because if I am, because that is how the question to you. If I am ensuring transfer to Bhadrak, how I will ensure that the child is not left alone?
Is nearer to that my home.
Correct, sir. Correct, madam. That is how.
It's nearer to the court.
So nearer means it has a house beside the court. Anyhow, the child has to be left at home. That order I cannot pass. It doesn't appeal to, common sense. How a lady will leave her child, should not leave, so that is how it should be the place of her stay. That will not ensure her child being attended. I cannot ensure. And threatens you have to file FIR or anything petition. And any adjournment you have sought for this family court for ailment, whether it has been considered. This court is not adjourning matters. The trial court is adjourning that matters. Yes, Mr. Bose.
My lord, there are three grounds which my learned friend assisted your lordship. First is distance, second is influence, third is her ailment. My lord,
child is fourth.
My lord may kindly see the cause title of this. My lord, I'll come one by one. How they have misrepresented and taken an order of stay. Your lordship may kindly see the cause title. At present residing at post Attapur, PS Soro, district Balasore. So it comes within the police station jurisdiction of Soro. Soro is the middle point of Bhadrak and Balasore. It is equidistance 35 kilometers to Bhadrak, 35 kilometers to
And Soro is in Balasore, not in Bhadrak.
Yes, but it is equidistance 35 kilometers on both the sides. Secondly, my lord may kindly turn to that petition paragraph 5. That the petitioner has filed an interim maintenance. Petitioner registered. Kindly see, madam. The petitioner has filed an interim maintenance. Petitioner registered as IA number such and such in same court. They suppress the fact that there was an order passed by the Learned Family Court granting 7,000 on 5/4/2024. The TRPC petition was filed on 21/8/2025. Once they suppress, means they are coming to this court with unclean hands. My lord, 1994 Supreme Court 653, Chengravellu Naidu covers the case. That anything which has been withheld from the court, it is playing fraud on the court. Your lordship may kindly see that judgment. That I have written specifically in my counter affidavit. This fact that it has been only registered, but she is getting maintenance from 5/2/2024 from the date of filing, she has suppressed before your lordship. Till today. And in my counter affidavit, I have stated, my lord, from April 2025,
So your case is that point goes. The last ones, residuary submission, she did that, she is not getting, because that I asked.
My lord, it's why the petition should be at all entertained, my lord. Because she is a wife. It will be entertained. She has suppressed that fact.
The unfortunate husbands engage you only, that you said.
Yes. I am always for the husband, my lord. My lord,
They become unfortunate after engaging you or before engaging?
before they become unfortunate, after engagement,
Good fortune to them.
Yes. My lord, this TRPC, your lordship may kindly dismiss on the ground that she has
I will not dismiss.
She has suppressed. But this is my suppression.
These things are now the part of the profession. Whenever there is a matrimonial cause, these kind of pleas are taken. Please.
No. Suppression. Suppression, it will be there, my lord. Suppression, it will be there. And when I bring it to
number 7.
Madam, please, sticker one.
କହିବେ ଆରେ ଶୀତ ଯେମିତି କହିଲେ ଆପଣ ଅପେକ୍ଷା କରନ୍ତୁ.
My lord, may kindly
you can take seat and hear him carefully. Chengalveru Naidu, I am obtained.
Yes.
They have quoted Lord Denning. Fraud unravels everything.
Once they are come to your lordship's court, once they come to your lordship's court, they should be in clean hands. My lord, if she would have written that yes, I am getting maintenance, would heaven would have fallen down, my lord? What's made them suppress?
No, it was my intuition.
Yes.
By my intuition, I asked that how much maintenance you are getting. Maybe she's getting maintenance.
Sitting continuously in the matrimonial bench, my lord knows what is the procedure of law. And my lord is well aware about the procedure. That whenever a divorce is filed by the husband, a 24 application is filed, a 125 is filed, DB under section 12 is filed. That's why in that other case, your lordship said that that means they are in good relation because no other 5 to 6 cases have been filed. My lord, what made them to suppress this fact? When I bring in the shape of an counter affidavit, by a rejoinder, they want to say that yes, I am getting, but from 25 I am not getting. My lord, I have admitted that in my counter affidavit from 25 I have not given. But your lordship may kindly see at paragraph 6 at page 3 of my counter affidavit, I have stated that from 25 onwards, he undertakes to pay very soon. My lord, he filed this case, and when I got the notice, I could have paid it. When I got the notice and proceeding is stayed, my lord, I will be paying the money, and my divorce application will not be taken up by the court. Because she has got a stay from the lordships. She has got a stay. If she is very much interested, then let her participate in the proceeding. And moreover, her distance, which he is saying, is equidistant to Baleswar. Now, second is influence. My lord, I am now posted as a home guard in Raibonia prior to even maintenance order was passed. I have given that document. Raibonia is the last part of the state of Orissa, bordering Lakhnath. Your lordship is well aware of that area. Raibonia is the last police station, after which the Bengal border starts. It is the last police station of Orissa. So I am there, my lord. So question of influence doesn't arise. And moreover, my lord, has she filed any application in the court below that I have threatened her or done anything?
So here, Mrs. Das is fair. She says that she has not filed any petition.
It's a fit.
Where she sought for adjournment rejected.
Nothing.
There is no complaint against anyone.
Yes. And moreover, my lord, she has engaged a lawyer there. Lawyer could defend her and get a maintenance of 7,000, which she is satisfied. She is not questioning that. I am also not questioning that maintenance. She is getting 7,000. My lord, why there will be a transfer? Unnecessary, my lord, I have to travel from Raibonia to...
Mr. Both, this has become a strategy actually. Whenever the notice is issued, you file a TRPC.
Yes.
And the whole scheme is frustrated.
Yes. That's why there is a cases in family.
Lingering cases, how does that help the wife also?
It helps the wife. My lord, I'm saying...
No.
Extraction of money.
Not extraction, don't be so harsh. Don't be so harsh.
Extract with that is the very.
No, Mrs. Das, actually, what you have heard, Mr. Mohanty.
I mean, being
Mr. Mohanty, you were there when Mr. Mohanty was addressing in the similar matter in Bhubaneswar. The husband has paid 14 lakhs already. Still, they are seeking adjournment. Here, 3 cases because of sitting in a division and having some difficulty in forgetting. Kunar case, after the amount is deposited, the wife falls ill, doesn't appear before the court. Then what is the effort of the court? You see, the court's effort to make the parties to come to a point of, because they are not willing to go together. What the court will do? Because you say that I'm staying in Madrak and you have got to obtain a stay order. And this, how it has helped you? That's my question.
Maintenance will not be coupled with the in case of
Definitely.
It is always a separate proceeding.
Definitely.
My lord will, while deciding permanent alimony, any court, be it trial court or be before your lordship will not take into account this money.
Because that is 54.
Yes.
I'm sorry, that is future.
This is a 24 application.
This is 24 and 25 and 25 is future.
Future.
In another case, after 30 lakhs is deposited, I'm telling you, not regarding this matter, how it has benefited this stay order, how it has benefited you. And how you are so successful in getting order in 24 and arguing the matter also there. After 24 is allowed, then you become so difficult.
No, my lord, what has happened? I'm just.
So if it is 1 year, then also you are ailing.
Generally, my lord, when you come up before your lordship in transfer petition, a first question is asked by the Honorable Court that have you been paid maintenance?
Correct.
As she did not write that maintenance of 7,000 is being, the court was inclined to issue notice and grant a stay. When I appeared and brought it to the knowledge of the Honorable Court that yes, 7,000 is being paid, they retracted and said they will file a rejoinder.
There is some other assignment I was told to rise at 4. But Madam Das, one thing as you should have sharp enough to what he said. He says that he will pay the amount. So you accept it and let the matter continue.
Yes.
He will pay the amount. And the next day he will pay the amount.
Virtually at least.
Virtually, sir, I cannot. You must understand the trial court, I don't have the jurisdiction. You make an application for virtual, they reject, then you come here.
My lord may dispose of, your lordship may fix, give me.
Stay order
is now.
No. I will vacate that. I will grant you the shortest possible adjournment.
Yes.
But please deposit the amount.
Yes, I'll deposit. I'll deposit.
So by which date? You tell. You take it.
You may grant me 15 days time. I'll deposit the money and bring it.
Now you are in win-win situation. You are having the cake as well as eating it.
But the stay order may not be extended. Learned trial court may proceed because divorce proceeding.
No, till the next date. I'm giving a fix. Apart date fix करो.
Sir, ଆପଣ order କରିଦିଅନ୍ତୁ ମୁଁ ଟଙ୍କା ଦେଇ
No, I'll pass that. I'll pass that.
Sir, your lordship may pass and dispose of it so that and the litigation ends.
With liberty to her if she doesn't receive the money.
Yes.
ठीक है. So at least you have won the case.
And at least
Because you are concerned for payment of alimony, payment of Section 24 maintenance parental right was taken care of by the trial court. You have to obtain the stay of that proceeding. Then where does the equity lies? This has not helped. This has not helped because Soro is nearer to Baleswar actually. And the distance you have written 60 and all this, how is it?
My house is there, I know it.
Yes, so it is not that distance.
Your lordship.
See, it is just possible that she may be belonging to that area. So we cannot say that. She may be aware of the local geography also. You belong to that district or other?
I right now I'm staying that, but not to that.
In person, you belong to that Bhadrak Baleswar districts or this side of Odisha? You are aware of that?
ना ना आपण कोठी
idea अच्छी की it is not 60 kilometers.
ना ना आपण person आपण को मोह किलो नो
आपनकर आइडिया अछि ना आपण जदि आर्ग्यू करछन्ती you should not argue facts like this जोतरे की problem हबो to sustain.
I belong to that. I have no instruction where the petitioner actually belongs. Original belongs.
आपण तो address सोर अछि.
Say it wrong. At present, say it wrong.
Soor 60 kilometers आपण केमती. That is a contrary to your anyway. I'll pass the order.
Dispose of money.
Yes, yes. Great. But liberty if you are not
liberty to file application through BC. Only grant me liberty.
Adjournments order उड़ा को कितने दा?
34 will come tomorrow, man.
36, Mr. J. Mahanti for the petitioner, Mr. A.P. Ray for the opposite party. The learned counsel for the opposite party prays for 2 weeks' time to file counter. Accordingly, the matter shall be listed in the week commencing 27/1/2026. Interim order passed earlier shall continue till the next date of hearing. Rest of the matters where you want adjournments, he will give you the date.
No, I want 34 may be taken up.
So it will be added to tomorrow's list. Or yes, it will be distributed, adjusted.
Yes, sir.
For item 32, my
adjournment दे देबे व्यस्त होतोनी. जदि लिस्टिंग पाई से डेफिनेटली लिस्ट हो. एई वीक रे डिस्ट्रीब्यूट कर देबे.
only grant me liberty to file an application to appear through BC in London.
अरे सेटा आपण बुझी परनांती. आपण you go through the CPC. This court is not supposed to enter into those aspects. The conducting court has all the power. Whenever they are not utilizing that power or wrong exercise of power or they are rejecting your prayer, we have a supervisory jurisdiction. I cannot presume and predict that the court will
there is a reported judgment.
Absolutely.
Which will help her that whenever an application is filed, VC mode can be accepted.
Absolutely.
And even evidence can be done in VC mode because there is nothing more to be
accepted. That I have been telling also.
In item 35, there is a noting that opposite party has not been appeared in that.
No, so the judicial order, we have gone up to which matter? Could last matter thila?
30.
Madam Das matter? 32 रे order किसी परे pass होबो नहीं. आपण जदि adjournment चाहुचंती ताले से दे देबे. Listing चाहुचंती से कोहे distribute कर देबे. 33 to 40 it will be distributed. I just change your list.
So may grant me 15 days, I'll pay this.
Yes, 2 years. Yes. 15 days is not much, Madam Das.
No, I'm
yes,
not
yes.
disputing that.
Yes. Thank you.